near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, all. Welcome to the Appellate Division First Department. Arguments for today, April 4. According to this, we have 5.5 hours of argument time requested. I was going to say we don't want to spend this time because the sun was out. Then I saw the sun is no longer out. So then I'll just say we would like to enjoy some weather without rain. Okay, so we don't want to be here all afternoon. So please only request the time that you actually need in order to get out the salient points of your arguments. Please keep in mind we have read your briefs. We are fully familiar with your briefs and with your arguments. People v. Zarof Taylor. Seven, 3, and 7. Gasama versus New York State Department of Housing.
Respondent, DHCR, request 4 minutes.
And the respondent, West 157, requests
5 and 2, 4 and 5. VP Children, that matter is submitted. Stringer v. Kim.
Appellate requests 6 and 3, Your Honor. And good morning, Your Honor. Respondent requests 7.
Good afternoon. 6 and 3 and 6. The morning has gone by. Thank you. Gibbs versus Manhattan Democratic Party.
Appellate request 7 and 3.
Good afternoon, Your Honor. Respondent is Manhattan Democratic Party requests 90 seconds.
90 seconds? Because the last time you requested a minute, and I think I gave you like 2, something like that.
He asked questions, so it was a good time.
Okay, I'm going to hold you to it. Okay. 5 and 2. The clock doesn't even do 90 seconds. I don't think I can do 90, right? No, it doesn't register 90. 5 and 2 and 1. BML Properties versus China Construction. 626. People v. Travis Woods.
Appellate requests 7 and 2, Your Honor. People request 8.
626. People v. Robert Moore. People v. Robert Moore. Sanders. Oh, I'm sorry. Thank you. Sanders v. Cooperative Rabobank. Apologies.
Good afternoon, Your Honor. Respondent requests 7.
626. Now, people v. Robert Moore.
Appellate requests 4 and 2, Your Honor. People request 6.
424. Hanover Company versus Home Depot.
Good afternoon, Your Honor. Appellate requests 6 and 2 and 3 on the response to the prosecute. And respondent Home Depot requests 6 and 3.
6262. People v. Tavon Johnson.
Good afternoon, appellant request 5 and 2.
424. Marel Finance v. Sutton.
Good afternoon. Appellant request 5 and 2.
Good afternoon. Respondent requests 4.
424. Sachs v. Marel. That matter is submitted. Balsamelo versus Structure Tone. That matter is submitted. Perez v. New York City Health and Hospitals. Submitted. Stavovic versus Shabbat, that matter is submitted. People v. Zarof Taylor, first case for argument. Whenever you're ready.
Good afternoon, Your Honors, and may it please the Court. My name is Lauren Cole from Howell, Schuster & Goldberg. I am pro bono counsel in association with the Office of the Appellate Defender on behalf of the appellant, Mr. Zarof Taylor. I'd like to begin with the ORAMA issue in this case. The foreperson asked whether or not the verdict on the first-degree murder charge had to be unanimous. Undisputedly, the parties were never even informed, and the jury did not receive an answer. That requires reversal of the first-degree murder conviction. Second, I would like to address that Mr. Taylor was deprived of his right to effective assistance of counsel at trial. Your Honors, this is an extraordinary case. Counsel here was on death's door, trying a first-degree murder.
Counsel, I'm sorry. I don't like that phrase. I don't believe that, I don't believe that, yeah, sorry. I don't believe he was at death's door, and I don't believe that we should characterize it as such. He was ill. He was undergoing chemotherapy for his cancer, but I don't like the phraseology that he was at death's door.
Yes, Your Honor.
And I'm sure at every turn he was hoping for it to be a different outcome for himself.
He did not know that he was going to die during the following the trial. So again, please don't use that phrase, and let's move on.
Okay, yes, Your Honor. So, at the time, Mr. Bruno is undergoing chemotherapy, and court has to be paused every week so that he
And
can.
Mr. Goldberg takes over for him, right?
Mr. Goldberg takes over during jury deliberations, that's
Right,
correct.
so wasn't there a point at which the defendant consented in writing to Mr. Goldberg taking over?
So, no, Your Honor. So there is
There's no
there is
written,
something in the
there's
record.
There's no written statement by the defendant stating that he consents to Mr. Goldberg continuing as co-counsel.
So Mr. Taylor's understanding from the court is that that was just until Mr. Bruno was able to come back. And in fact, later the court
The statement was that he consented to Mr. Goldberg as co-counsel during the proceedings. Is that not what the statement was?
Yes, as co-counsel during the proceedings.
And so
not
you're
as,
stating that your client thought this meant what?
that he thought that this meant that, Mr. Bruno was having some issues that day, but that he would in fact be back
For
to
for
represent.
deliberations.
Yes, Your Honor.
So co-counsel couldn't represent him for deliberations even though he consented to it.
Well, so, Your Honor, the concern from Mr. Taylor is that a new counsel was being brought in who knew absolutely
New counsel
nothing.
is not being brought in. We're talking about deliberations. We're also, my understanding of the record also is that Mr. Goldberg was on telephone alert or calls, had the ability to communicate with Mr. Bruno. So Mr. Bruno was on call, and if there were any issues, and this was made clear, my understanding, that this was made clear to the defendant and to the parties, that should Mr. Goldberg have any questions, et cetera, concerning what was going on, he would reach out to Mr. Bruno, because Mr. Bruno was available for that.
So respectfully, Your Honor, Mr. Bruno was in no position to be rendering any sort of
Based
aid.
on what? What do you base that upon?
Well, based on Mr. Goldberg's statements himself after he spoke with Mr. Bruno.
Mr. Goldberg, his affidavit talks about Mr. Bruno's physical condition in that he was ill, and he was ill because of the effects of the chemo, meaning that he was throwing up, he was vomiting. That was one thing. Mr. Goldberg, in his affidavit, never made mention of any mental issues or inability of Mr. Bruno to understand what was going on, nor did the judge in this matter, nor the other participants in this case mention any issues as to Mr. Bruno's mental capacity.
Yes, but Your
In
Honor.
fact, your client never complained about Mr. Bruno throughout the trial, correct?
It's correct that Mr. Taylor did not seek to replace his attorney in the middle.
No,
of the
not
first
even
degree.
seek to replace him. He never uttered any issue or any statement that there was any issue with Mr. Bruno's representation.
Yes, but so I think it's important to look to the record in this case. And the
Yes,
record
let's
is
look at
quite,
the record.
Yes.
What about the cross-examination of witnesses? Did Mr. Bruno cross-examine the witnesses presented by the people?
He was there to cross-examine.
Was there anything deficient in his cross-examination of those witnesses?
Yes, Your Honor.
Where?
So with respect to Mr. Santiago, who had a clear motive to curry favor with the prosecution, Mr. Santiago is facing charges in Pennsylvania, and he at first balks at testifying, says that he's not going to testify, and then he writes a letter,
What does that have to do with cross-examination, counsel?
Yes, so I'm getting there. I appreciate that. I'm sorry. So he had a clear motive to curry favor with the prosecution because he could have gotten some sort of benefit from his testimony, and Mr. Bruno never makes any attempt to develop any record in that regard.
So this never came out at trial in terms of Mr. Santiago and his complicity in the crime, as well as any quote-unquote relationship that he had with the prosecution?
No, so Mr. Bruno does not make any sort of effort to elicit that here Mr. Santiago had a clear motive to curry favor, that he had a clear
And
motive.
why did he
here
have a
to
clear
not-
motive to curry favor?
So, as I said, he initially balked at testifying. He did not want to testify. But then he, sort of on the eve of trial, he decides to testify. He's facing charges in Pennsylvania. And he may get some sort of recommendation or a benefit on behalf of...
Was there anything, or any statement that by the prosecution, because the prosecution obviously would have to bring this to light. Was there any statement by the prosecution that in fact Mr. Santiago would be receiving any type of leniency in Pennsylvania?
So I see that my time is up, but I would like to address your
Please.
question. Yes. So the prosecution does not directly say that he is going to get a benefit. They say that he's not likely to get a benefit. And so communicating to Mr. Santiago that he's not likely to get a benefit is very different from communicating that there's no possibility of a benefit at all.
I didn't understand that, but I'll think about it. Thank you.
Thank you.
Good afternoon, Your Honors. Vincent Revelisi for the people.
So why don't you pick up on the last point made by defense counsel, that the cross-examination of Mr. Santiago by Mr. Bruno was deficient because he didn't elicit the fact that Santiago stood to benefit from his testimony.
Well, he wasn't promised anything. So Santiago was arrested in Pennsylvania, not in New York. So there was no connection to the New York criminal justice system. And he wasn't promised anything. And in fact, the defense attorney did make fun of his prison tunic and talk about him in a derogatory way in trying to impugn his credibility. So it wasn't that he didn't attack his credibility. He just didn't attack it in exactly the way that counsel is suggesting he could have done, which would have been to spend more time cross-examining about Pennsylvania. Of course, he had a lawyer and a nurse present, and he wasn't likely to answer questions about his Pennsylvania case because he would invoke the Fifth Amendment.
And the premise that he would be getting some sort of benefit is mere speculation, not reflected in the
Correct.
record anywhere.
Correct. He was not promised anything. And so he could have pursued that different area of cross-examination, but he chose instead to impugn his credibility through his character. He had stolen the mini bike. He had been arrested in a gunfight in Pennsylvania. So there wasn't really much else he could say that would have brought out information about the Pennsylvania case since he had his lawyer present. I do agree that because Mr. Bruno had cancer is not a reason to find him ineffective. It's the performance that matters. The illness is something that is a personal circumstance that anybody would be dealing with, any kind of personal circumstance in their life, and the representation that the defendant received should be the gauge for this court to review.
Counsel, the people reference a phrase of presumptively ineffective. Is there any support for that in any case law surrounding ineffective assistance of counsel?
No, that was in response to the defendant's argument about the chronic case, saying that if you're effectively without counsel, or if your counsel can't possibly provide effective assistance, that you wouldn't have to show prejudice. But in this case, there's no presumption that because you have cancer, you can't be effective. So the real inquiry is whether he was effective, no matter whether he was sick or not. You could be perfectly healthy and be ineffective, but you can be sick and be effective. So here, the court did review that in the 330 and the 440. They found that he was effective. The attorney and the judge had both had cases with Mr. Bruno before, and they said that they knew him from previous cases. They considered him to have been basically the same, except a little bit short of breath at times. So there was no reason to find him ineffective based on the cancer.
Let's talk about when Mr. Goldberg was appointed. Was Mr. Goldberg given an opportunity to review the record?
Yes.
And the proceedings were paused for that opportunity, correct?
That is correct.
And that was during deliberations, is that correct?
Yes, and then really nothing else happened anyway, but he had reviewed the record just in case there was a jury note that he'd have to help answer or help with formulating the answer.
And he did have the opportunity to contact Mr. Bruno if there were any issues.
Yes. And in fact, after Mr. Goldberg said that Mr. Bruno seemed very sick, the judge spoke to him on the phone. Mr. Bruno said that he'd be available if there were any questions. And the judge said he sounded like he was absolutely sure that he would be able to
I
help.
appreciate you say that there was this opportunity to review the record, but this trial had gone on for some time. I mean, and you didn't wait days for Mr. Goldberg to get up to speed on the case. I mean, what does it really mean? He had the record, but what is he reviewing? I mean...
Well, they waited a few days for him to read the transcript of the entire trial, which he did. It wasn't crazy long. It was a few hundred pages, but they did give him the few days. He read it over the weekend, and then when they were supposed to come back Monday, a juror wasn't ready, so they came back on Tuesday. So he had about 4 days to review the record, and he said that he had reviewed it before they continued. But then when they continued, nothing happened. So there wasn't anything that he had to participate in anyway other than polling the jury after the verdict.
So chronologically now, Mr. Goldberg comes onto the case. The jury is deliberating. At what point in time does the jury reach a verdict?
It's about a day after Goldberg starts representing the defendant in the courtroom when Bruno is on phone alert. So that would be the Tuesday after the weekend when he read the record.
Are there any notes from the jury at the time that Mr. Goldberg takes over?
There were no notes for him to respond to. There was one note outstanding that hadn't yet been answered, which is when the jury had 2 notes. They had one note about the partial verdict and one note about whether they wanted to talk to the judge. The judge said, which one do you want to do first? This is while Bruno was still there. Took the partial verdict, and they didn't answer the other note right away at that point. The other note was whether the jury wanted to talk to the judge. On the first time that Goldberg was there, the jury then said they didn't need to talk to the judge. So that they answered that note of whether they wanted to talk to the judge that they didn't, and that was in Goldberg's presence. But he didn't have to do anything.
Right, and so now your adversary made reference to the note wherein the jury asked whether the verdict had to be unanimous.
That was a single juror after the judge halted deliberations and said that everyone would leave until they came back, not to deliberate. That juror just said, I just want to ask you if it has to be unanimous, and the judge said, I'm not answering any questions.
How was
So
that
the parties were
ultimately
gone.
handled?
I'm sorry?
How was that query ultimately handled, though?
It wasn't. The judge just said, I can't answer any questions. You'll have to ask me a question as the jury when we're back in session, and then they never did. So he didn't answer the note, and there was nothing done. It was only a single juror. It wasn't a question from the jury, pursuant to the statute. It would be a question from the jury that would have to be discussed with the parties.
So there was no direction that if there was a question, that question should be memorialized in a note and provided to the judge?
The judge said to that single juror, I'm not answering any questions until everybody's back together in court. The parties were already gone. And so he didn't answer it at all.
So is this an actual jury note? Because jury notes are supposed to be signed by the foreperson, right? So was it the foreperson who sent this note asking whether or not the verdict had to be unanimous?
It was no note. It was just the foreperson asking the question orally, and the judge saying, I'm not answering that now because everybody's gone. So it didn't turn into a note, and it wasn't on the behalf of the jury. It was just that single question. The case.
So is it a jury note? Is it an actual jury note? Is it an actual exhibit? Jury note 10 or 9 or whatever, or is it
no
just?
note. That was just oral. There was no note at all.
It was oral.
No note at all. Right. The case that the defendant cites in their brief, I believe it was called McGuire, was when the judge answered a single juror's question, and that was found to violate ORAMA. But in this case, the judge just said, I'm not answering any questions.
So my understanding is the case law not that if a juror makes asks a question orally to the judge, that the judge does not have to respond, and it is not considered to be an actual communication or note from the jury because it has to be reduced to writing and signed by the foreperson?
Well, the statute says writing, and then the McGuire case that they cite said this case was oral, but it still applies. But in the McGuire case, the judge actually answered the question, and here the judge didn't do that. I see that my time is up, so I'll ask the court to affirm on the brief.
Thank you.
Thank you, Your Honors. If I may quickly, I just want to go back to the ORAMA point. So the statute does not say that the inquiry has to be in writing. It says any time that the jury requests during their deliberations instruction on deliberations or on the law, then the court has to notify the parties and answer it. And indisputably, that wasn't done here. And the case law has not made any distinctions between
Well, was it
oral
the
and
jury
written.
or just a spontaneous question from a juror?
It's a question from the foreperson. It's an oral question from the foreperson. And, as I said, the courts have made no distinction between whether or not ORAMA has to be followed if it's an oral versus a written question. And then, if I may, I want to...
I was under the impression that the statute said that any communications from the jury have to be in writing.
The statute does not say that any communication from the jury has to be in writing. It just says that if they request further instruction from the court, that notice has to be provided to the parties and that the question has to be answered. So if I may, I also want to discuss, go back to the ineffective assistance
Well, let's
of
stay
counsel.
with that point for 1 second. So you're stating that because the juror asked whether the verdict had to be unanimous, the judge did not respond to that, and then there was a break, and then the jury subsequently came back with a verdict, that requires reversal of the conviction?
Yes, Your Honor.
And why would that be?
Because the ORAMA strictures have to be followed under the case law. So if the parties are not provided notice, I mean, this is in recognition of just how crucial and important jury deliberations are in our criminal justice system, that if the parties are not given notice and an opportunity...
I'm sorry, was this not an open court with the foreperson? I thought it was an oral question by the foreperson as to whether the verdict had to be unanimous.
It was an oral question, but the parties had left for the day. So they were not there. They did not have notice of the question from the
When
foreperson.
you're saying the parties weren't there, you mean the attorneys remained behind?
Correct.
Or the courtroom was empty?
I'm sorry?
Or the courtroom was empty but for the judge and the clerk and the jurors?
Yes, so the parties had
Which?
left.
Which?
She's asking who was present.
The court and the clerk were present, yes.
I'm sorry?
The court was present and the clerk, yes.
And not the lawyers?
No, the lawyers had left for the day.
So you had the full jury, and you had the judge, and you had the clerk, and that was it in the courtroom?
That's my understanding, Your Honor.
And the judge said, I don't answer questions unless everyone is here, correct?
The judge said that he did not want to answer questions while the parties weren't there, but that he would be happy to answer questions once the parties were there.
Thank you.
Thank you.
Thank you both. Thank you to your firm for allowing you to do this pro bono. We appreciate it. Thank you. Gasama versus New York State Department of Housing.
Good afternoon, Your Honors. This is David Singer of Counsel to the Legal Aid Society for Petitioner Appellant Milan Gasama. The DHCR decision denying Mr. Gasama's PAR was both arbitrary and capricious and an error of law under the binding authority of Grimm and Thornton and under the laws passed this winter. Mr. Gasama seeks a remand to DHCR for consideration of the evidence before it, consistent with the new laws. These new laws codify Grimm and Thornton. They make it clear that the changes are effective immediately, or the codification is effective immediately. And it holds that there need not be a finding that all the
So
elements
did
of
this
common law
apartment or this unit ever fall out of rent stabilization?
It was never registered as not as market rate. What happened was there were a series of 4 quite egregious license agreements that I'm sure this court is familiar with that both waived Mr. Gasama's rights under the rent stabilization law and code, as well as even his rights as a tenant. It
Purported to waive.
Pardon?
That purported.
Purported, thank you. Thank you.
They didn't, right?
Didn't.
They didn't waive any of his rights as a tenant.
He signed all of these 4 license
But he was
agreements.
able to advocate as a tenant under the rent stabilization law, correct?
Correct, but only after allocution by a judge in one of the non-payment proceedings that respondent landlord had brought, where the judge said, you're likely rent stabilized, you should check out your rent history. And at that point—
So did it ever reach a point in terms of rent stabilization when, based upon the amount of the rent, it could have been taken out of rent stabilization?
Even on the landlord's numbers, the highest that the rent could have been was $1,900, so it never reached the deregulation threshold for high rent vacancy destab. And the case law makes it clear that even if the jump in the rent doesn't get you to the other side of the proper high rent vacancy destab, it still can be a fraudulent scheme to deregulate the apartment or a fraudulent scheme to overcharge under 435 CPW, Central Park West, which was this court's case just a few years ago. So
So let me jump in. The license agreement is quite a remarkable document.
It is.
It says that the tenant was not subject to rent regulations. He had a temporary license to be there, and basically that he wasn't even a month-to-month tenant, even though he was a rent-stabilized tenant.
Right.
The landlord does a rollback once. I'm going to call it a scheme. How's that? Once the scheme is uncovered, the landlord rolls the dollar amount back and says, "Oh, I'm going to go back to the $1,550." Is it?
It is.
That the original tenant, after renovations, paid, and that covers several years, right? And there's also a return of money, a reimbursement of the overage. Why isn't that enough here?
Yeah, so that argument presupposes that Mr. Gasama would not be able to prove fraud. And as Mr. Gasama asks here for remand to DHCR to properly consider the evidence of fraud that was actually provided.
DHCR considered, even though it said we're just going to go back 4 years, they went past 4 years, didn't they? Didn't they look at everything?
They did look at the IAI evidence. However, their consideration of that evidence was cursory at best. It involved
why so?
So it involved roughly $6,300 worth of charges that either the invoices showed the work was done at a different apartment, it was to a different unit in the building, it was to a common area in the building.
Was it a different unit or just labeled as basement with a different?
So there was basement, there was hallway, there were the apartment down the block, or I don't know where these other addresses were. I do have the citations to them, but it was very clear that DHCR was just engaging in a rubber stamp of the landlord's documentation. And under the controlling case law—
So are you challenging that?
Yes, we are. Under the controlling case law, there's two separate inquiries, and this is exactly what happened in Grimm. There's the first issue, which is, has the tenant proffered enough evidence that of a fraudulent scheme to deregulate or to overcharge that it obliges DHCR to actually pass upon the sufficiency of the evidence and determine whether the tenant has stated a claim for actual damages. So
is your issue that the determination was based on a lousy evaluation?
So it's twofold. One is that DHCR considered all the many indicia of fraud that were offered and considered each one in isolation. They considered the increase in rent under the IAI and said this on its own is not enough, citing Boyd. They considered a failure to register, and even in DHCR's appeals brief, they said this in and of itself is not enough. That's Mr. Gasama's point. In and of enough is not the current standard. Thank you.
May it please the court, my name is Sandra Joseph for the respondent DHCR. DHCR went beyond the 4-year rule and looked at the evidence as to whether the tenant was overcharged. In this case, we went back to 2009 when the original tenant was in there, and the rent was $876. When that tenant vacated the apartment, the owner was entitled to a vacancy increase that brought the rent at that point to 11, I believe, 63. At the same time, because it was a long-term tenant, they also performed IAIs, and actually the rent at that point exceeded the $1,550. It was insufficient to deregulate the apartment, but it was still greater.
So the IAIs were $17,066.80. Was that documented? Because your adversary seems to suggest that.
It was well documented, and as our order states, we used policy statement 9010, which at the time was the
There were canceled checks, weren't there? There
Pardon?
were canceled checks, weren't there?
We had canceled checks, we had contracts, everything that comported to policy statement 9010, which made the IAIs comparable.
Counsel, what about this allegation by your adversary that the improvements were for apartments down the block, around the corner, addresses unknown?
We didn't have any evidence to that nature at that point. They never presented anything. The only thing my adversary kept alleging was this was an 76% rent increase without taking into consideration the vacancy allowance, the IAIs, or the MCI that the owner was entitled to collect that he didn't collect.
Well, there was a DLB sign-off, wasn't there?
There was also, if I remember correctly, there was a permit for the work, and there was a DOB sign-off
And the
on it.
DLB sign-off, was that for that particular unit, or was it for someplace down the block?
I couldn't actually answer that. Maybe the owner can clarify that for you.
Counsel, did you take into consideration the lease agreement that was provided?
I'm sorry.
Did you take into consideration the lease agreement that was provided to the tenant
Well,
in discerning whether or not there was fraud?
Well, what happened is once at that time in the rent stabilization law, there was something called the safe harbor provision, where the owner, once the overcharge was presented to them, they then rolled back the rent and also offered the tenant a rent stabilized lease, which from my understanding to this day has failed to be signed.
And counsel, did you also take into consideration that at the time the petitioner was in arrears upwards of $30,000?
That, we also took that into consideration because the rent wasn't paid, so it's hard to have an overcharge if you don't pay the rent. If you have any further questions, otherwise, thank you.
Good afternoon. May it please the court. Paul Coppy from Rose and Rose for the respondent. West 152nd landlord. I'll just touch on a few supplemental points. There's been a lot of discussion at this argument on both sides and in the briefs of fraud. I think it's important, therefore, to note that the original rent overcharge complaint that was filed by Mr. Gasama did not allege fraud at all. No fraud was alleged, no discussion.
Counsel, but now here we are talking about fraud. Can you speak to the license agreement that was countenanced as a scheme and how that plays into the issue of fraud?
The license agreement, well, a couple of points. And a key point is that the license agreement occurred subsequent to the base date. Fraud.
Subsequent to what?
The base date, the date 4 years prior to.
Counsel, let's be real. But for the fact that your client brought a holdover proceeding instead of a non-payment proceeding and did not indicate that the apartment was rent stabilized, but for the fact that the judge said, I think this apartment is rent stabilized, this tenant would be out of the apartment, right? Never knowing that he had rent stabilized status.
That is possible, although somewhat speculative, but it's...
Really? How is it speculative, please?
We don't know what happened,
You
what
want to
would
see
have
the,
happened.
you want to
Didn't
see the
happen.
license agreement and tell me how this is speculative? Let's try.
It's impossible to say what would have happened had the case turned out differently. But be that as it may, also,
I mean, under the license agreement, how could he have evicted? What would he need to do in order to evict the tenants?
well, he would have, at minimum, had to show that the tenants
You'd still have to go to court, right?
still have to go to court. I'll note as well that it's a misstatement to say that there were 4 license agreements. The renewals referred to all of them as leases. The Rent Stabilization Code also provides that a lease, to the extent that it contains illegal terms, is nonetheless enforceable as a lease to the extent that it doesn't contain illegal
The
terms.
landlord would have always had problems evicting this tenant in the face of that license agreement, because any judge that the case came in front of would have looked at this issue, presumably.
Presumably, that's correct. I would still like to return, though, to the rule of Casey versus White House Estates. It's a recent Court of Appeals case. It stands very clearly for the proposition that post-base date conduct cannot taint the legality of the base date rent. And DHCR's holding here fundamentally relies on the fact that the base date rent was not tainted by fraud at all. It just wasn't. The IAIs were amply documented. The work that was done in 2010 was not only signed off by the Department of Buildings and not only paid for, it was all submitted to the Department of Buildings by a registered architect who obtained all the requisite permits to do.
Also, how do you respond to your friend's argument that the IAIs weren't for the apartment in question?
That's simply false. It's not borne out by
So I
the
asked about the
documentation at all.
DLB and the DLB sign-offs. Were any of the documentation presented specific to this unit? Did they specifically state this unit?
The architect's invoice references basement apartment. Let's see what else.
Was there
is
more
here.
than one basement apartment or just one?
There was only one that was vacant at the time. There
How
were,
is-
I believe, 2.
I don't know, so there's more than one, right? I mean, is there something that says you could not do work on the vacant basement apartment?
I'm sorry?
Is there something that says that the architect or whomever could not have done, that there could not have been renovations to the vacant basement apartment? I mean, I don't understand, I'm not sure that that really answers the question as to how we know that the improvements were to this specific basement apartment.
Well, let me, there's about 70 pages of backup here. So let's see. What's here?
Thank you.
All right, thank you.
I'd like to start by just emphasizing that many of both DHCR and the landlord's arguments presuppose that Mr. Gasama, after remand to DHCR, would not be able to prove fraud, and therefore that the rent was properly set based on the base date and not going back to what the rent was before that period. I'd also like to stress that in terms of this duping that went on in the license agreement, Judge Friedman rose the fact of what the judge would say, and it would be hard to get it by any judge, the egregious terms in it. But that's irrelevant what the judge says. I'd like to focus the analysis, which is really the import of this whole case, on what the consequences are if DHCR's analysis of fraud law is able to stand. It really could spell the end of rent regulation, and I know that's a pretty strong thing to say.
What about what what counsel for DHCR said about the safe harbor provision?
Yeah, so the safe harbor provision, again, that presupposes that the refund was at an adequate amount. But if Mr. Gasama is able, after remand to DHCR, to prove that the IAI was fraudulent or other things, and that the base date should not be the basis of calculation of his proper rent, then it wasn't an adequate refund.
Are
And I'd
his
like to-
arrears relevant at all?
Yes, Your Honor, I am glad you mentioned that. So the period over which Mr. Gasama was in arrears ended in the period which he started to be in arrears started in December of 2016. So he had a full 3 years in the apartment keeping up with the rent, the illegal inflated rent. And if you look at the
Well,
that
I mean,
rent
that's
history-
fantastic that he kept up with the rent for that amount of time. What happened after that?
After that, that was right around when he was allocated and thought that it was rent stabilized, and he began withholding the rent. And the site.
And he withheld the rent for how long?
Pardon?
He withheld the rent for how long?
He still is withholding the rent, except
Since
he is in
2016?
compliance- He is in compliance with the this court's order for use and occupancy pending the appeal of his other proceeding, which is an ejectment. He is, but for the OSC that was signed, he could have been evicted during or ejected during the pendency of this appeal based on an illegal rent that he had been induced to.
So he's been withholding rent since 2016 or 2017?
That's my understanding, is that he had stopped paying rent at the point in, and the site to the breakdown is at A413 through 19.
And hopefully the money's in escrow.
Yes.
Thank you. Thank you all.
Thank you.
Stringer v. Kim.
May I proceed?
Please.
Walden, Mock, and Haran by Milton Williams for Appellant Scott Stringer. Your Honors, I would like to reverse the order of the argument that is the way we presented in the briefs. I would like to start with reasonable foreseeability. Here you have a case, okay, and I'm looking at Giffer versus Maxwell, and also the interplay with Judge Littman's well-reasoned opinion in Gerasi versus Probst, although it came out against the appellant in that matter. I think it's dispositive here. Here you have an individual who describes herself in her own papers as an intelligent professional woman who had an excellent reputation in the community as a political consultant and lobbyist for years. She, before actually having the press conference back in April of 2021, shopped the story around to news outlets such as the New York Times. Then she sent a press advisory before the actual press conference. Then she held a press conference where a lot of people were there. They heard all these allegations of sexual assault. And the press conference, I would argue, is a step further, maybe 2 steps further, than the press release that was discussed by Judge Sweet in Giffer versus Maxwell. And then to take it a step further, after the press conference, in her stand-up comedic routine, the defendant respondent, used this very same material. And so then I would argue that it was obvious from this type of conduct that she plainly intended for her comments, these defamatory comments, to be republished and therefore authorized them. But here you have, and it was only a year later that they were republished. But you have a little bit more here in terms of reasonable foreseeability, because during the time period from May of 2021 all the way until August of 2022, August 20th of 2022, there was no mention, no news coverage with regard to the allegations against Appellate Stringer. Nothing, it was the press cycle was dormant. And then you have, and also during that same time period, Carolyn Maloney, who republished the statements on August 20th, 2022, never ever mentioned Scott Stringer or the allegations. Ms. Kim, in the heat of the battle between Ms. Maloney and Mr. Nadler.
There's an August 3rd, 2022 meeting or
That's right.
rally. Yeah, and there's a picture of that event, isn't there?
Yeah, there is. There is a picture, and so what I'm saying, it was completely dormant. Then on August 3rd, 2020, 2022, I'm sorry, you have the picture of them together. There was no mention of it. You know, this was in the heat of the campaign battle between Mr. Nadler and Miss Maloney. Mr. Nadler is well known to be Mr.
And
Stringer's.
then it's shortly thereafter that the story reappears.
17 days later. And so, just on reasonable foreseeability, even if you didn't have what occurred between August 3rd and August 20th, I would submit to this court that there's enough on reasonable foreseeability. It's interesting, in Jurassic versus Probst, Judge Lippman noted that he didn't even focus on the fact that there was a 3-year hiatus between the letter being sent to the FDNY and the republishing in the newspaper. What he focused on was the fact that the defendant responded there was not responsible for having contact or sending the letter to the newspaper. We don't have that here because we have an instance where there was a press conference used in the stand-up comic routine. So clearly, even if you didn't have what transpired between August 3rd and August 20th of 2022, I'd submit to this court that you have enough for reasonable foreseeability.
So, counsel, can you contrast Martin, where a Daily News article was published and where allegedly defamatory language was used, and it was considered restoration as opposed to republication because there was a change in the computer system and it was considered to be similar to a delayed recirculation. So is this a delayed recirculation, or is this a republication, or is this something else?
So, Your Honor, I'm submitting to this court that it is a republication, which was reasonably foreseeable based on the conduct with the press release. And then you have the extra added facts, if you're drawing all inferences in favor of the plaintiff appellant here. If you're drawing all inferences in favor, you also have the activity, the dormancy in the press cycle, and then all of a sudden you have the activity between August 3rd and August 20th. And if I may shift for a second.
But one second.
Certainly.
But for republication, do you not need some evidence of control by Ms. Kim over Carolyn Maloney, Ms. Maloney, in her statements?
Well, evidence of control, so Your Honor, you have to have, I think the operative language is, and I think this was cited in the Jurassic versus Probst, a republication may be, and it's based on a restatement of tort second, a republication may be foreseeable when the originator of the statement widely disseminated the defamation and thus intimated to those who heard it that she is not unwilling to have it known to a large number of people.
Does it also not say have some control over the third party, that the original speaker, in this case Ms. Kim, have some control over the third party and the decision to republish?
Well, to make it, when you talk about control, there's also authorization. And so here I would argue the authorization prong. In other words,
And what would the authorization be?
So the authorization, that's the first argument in our brief, and that is, it was, you had the activity in April 2021. It was basically dormant in the news cycle from May 2021 to August 2022. And then all of a sudden, someone who is, by our own admission, a political consultant, well-known, has this meeting.
Consultant to the speaker, to the person who?
No, just a political consultant in general, Your Honor. In other words, it's not someone who is new or not an experienced person with regard to how political issues are handled. And so she shows up at this meeting, at this intimate campaign event. She's pictured with her, and 17.
So you're arguing that she either played a role or authorized Congresswoman Maloney's statement?
Authorized, yes, and even drawing all inferences in favor of the plaintiff. And I'd also just go back.
Counsel, what here takes us out of the context of a political campaign where one party knew about these allegations and referenced the statement or the allegations in the context of this sort of political campaign?
You know what takes it out of it, Your Honor? I believe the dormancy. I think that's a dispositive fact here.
Well, the dormancy, I mean, but now we have a new race. we have a race now between Carolyn Maloney and Mr. Nadler. So would not now we drudge up whatever we're going to drudge up in order to assist Ms. Maloney?
So the way I would address that, Your Honor, is Miss Maloney, and the campaign had been going on against Mr. Nadler for a while at that point. In August. They never.
It was going on for a while, but when did your client start appearing with Mr. Nadler? Is that not when this was
No,
stated?
Mr. Nadler, the inference from the record, Your Honor, is that Mr. Nadler and Mr. Stringer knew each other for years, and it was well known that Mr. Nadler was one of Mr.
I know
Stringer's.
that. I'm talking about when they started campaigning together, because that was a context in which it was brought out again, correct?
Understood, Your Honor. All I'm pointing out is that, and I think the best way, the only way I can answer your question, is that drawing all inferences in favor of the appellant plaintiff here, there was no mention of Mr. Stringer at all, or these allegations, until 17 days after this meeting. And if you draw all inferences in favor of the plaintiff, plus combined with the second point that we made in our briefing involving reasonable foreseeability, I would submit to this court that there's more than enough for you to reverse the lower court's decision.
Thank you.
And good afternoon. My name is Mark Cohan. I'm appearing for Respondent Kim today. And let me start off by making clear that this is a case about a story created from a single photograph. All of the arguments that appellant presents to this court presume but do not introduce a single fact in the record to demonstrate that there was a meeting between the respondent and Congresswoman Maloney. The only thing they have is a photograph showing that Ms. Kim was at a campaign event with more than 10 other people, a photograph taken out of doors by an unknown photographer.
A photograph where the parties are close to each other.
They're standing right next to each other. Congresswoman
In the
Maloney
photogra-
has her hand on her.
In the photograph, what you are seeing is they are this far apart, and the hand, if I may, to Mr. Williams, is like this. This is not an embrace. This is, for anybody who's been at a political event,
So,
this is not
counsel, are
even
you
a grin and
conceding
grip.
that discovery is needed? Are you conceding that discovery is needed in order to discern?
No, I'm not, Your Honor.
No, I didn't finish.
I'm sorry, Your Honor.
Thank you. In order to discern the circumstances of that particular photograph?
I'm not, because I do not believe that the photograph is sufficient to raise a question for which discovery must take place.
What about the temporal proximity issues raised by your
I'm
adversary?
terribly sorry, Your Honor, I didn't hear the question. I'm a little hard of hearing.
So am I. What about the temporal proximity issues raised by your adversary?
The temporal proximity issues go to the question of foreseeability, and they would presume that there had to have been either some control or some authority. The mere fact that Congresswoman Maloney, in the heat of a campaign, made an observation that Congressmember Nadler was campaigning with somebody who had been accused by two different people of sexual harassment without naming the person who was accused of sexual harassment is not exactly the full-throated republication that appellant would suggest to this court. At most, it is a tepid statement that attempts to focus light, as Your Honor pointed out, in the heat of a campaign on Congressmember Nadler.
Do we have an affidavit from the Congresswoman to explain the photograph?
No, we do
Or
not.
her use of the
But
language
I would submit,
in the
Your
New
Honor,
York?
we don't need a
No,
photograph.
no, I didn't
I'm
finish.
sorry again.
It's all right. I'll go like
I
this.
apologize.
Do we have any explanation from her as to her statements in the New York Post?
No, Your Honor, and I would submit that no statements or explanation of the photograph are necessary because the burden here is on the appellant, the plaintiff below, and that even assuming all favorable inferences, there's not sufficient facts to demonstrate that there was control or authority.
Isn't that the issue, though? We're at 30-11, so assuming all reasonable inferences, we have the photograph, you explain it one way, your adversary explains it another way. We then have statements later on by Carolyn Maloney concerning her adversary, Mr. Nadler's relationship with Mr. Stringer. So taking all of that into consideration, why should the case not proceed? And then you obtain an affidavit from Ms. Maloney, et cetera, explaining exactly what was going on.
Because, Your Honor, even assuming all of what you suggested, there was not republication, which is a threshold requirement for moving forward in this matter. There was not republication because there was no defamation. Ms. Nadler, in her Congresswoman Maloney, in her statement, does not name the appellant. Congresswoman Maloney does not say anything that is not on its face completely true.
Yes, but that's where the picture comes in, you know. These accusations, we know that your client has made these accusations in the past, and then you have this August 3rd, 2022 event at which your client is present with Congressman Maloney. They're standing right next to each other. So that's where that's where the inference that the Congresswoman's accusations may have come from your client, which are then 17 days later republished in the papers after it had been quiet for so long.
I would submit, Your Honor, though, that that is a dangerous inference or assumption to be made in this context. It basically says that any woman who has made an accusation of sexual harassment and is engaged in a profession, such as Ms. Kim is, a political profession, cannot attend a campaign event under risk that the person might in fact...
I don't see how you make that leap. I don't understand that.
Because the
I mean, this rides on what the Congresswoman said, not on what Ms. Kim said. It's that these accusations are then repeated by Congresswoman Maloney.
The accusations, in fact, were not repeated, Your Honor, which is part of the reason there's no defamation.
They didn't name a specific person, but those who know the public record know to whom reference was being made.
And all Congresswoman Maloney said, which was an accurate statement of the state of the facts, is that there's been an accusation by two women against the appellant. That's all.
The statement was couched in accusation?
Pardon?
The statement was couched in it being an accusation?
Yeah, that's entirely correct, Your Honor.
The statement was someone who claims to fight for women's rights, but openly campaigns with a man accused of sexual assault is not who voters should send back to Washington during an extremely fragile moment for women's rights.
With no statement of the appellant, no statement and belief that the accusations are in fact true, no description of what those facts are, and I would submit...
So was Mr. Nadler campaigning with any other individual who had been accused of sexual assault?
I have no idea, Your Honor. I would note that New York is a pretty target-rich environment at this point in terms of politicians.
What kind of rich environment?
Pardon?
What you said?
Yes, I would submit that New York is a pretty target-rich environment.
Target-rich.
Democrats being accused of
Yeah, we have the
sexual harassment.
Democratic committee here somewhere, so they may take offense to that. But
I would submit
again, Counsel, I'm not really understanding your argument in terms of why then we should not receive something from Congresswoman Maloney in terms of exactly who she was referring to and what she was referring to.
Because, Your Honor, in a case such as this, the burden is on the plaintiff at trial court to come forward with evidence sufficient to establish a cause of action, not evidence sufficient to require a court to want to make further inquiry. Here, it is our position that appellant did not come forward with that evidence. They only have a photograph, and then they've concocted a narrative based on that photograph that they're asking this court to believe the trial
Counsel,
court
is
did
it
not.
concocting a narrative or asking the court to draw reasonable inferences that the court's legally required to do?
Well, I would say, Your Honor, they're concocting a narrative because, among other things, they are alluding continuously in their papers to a meeting that they allege took place between Ms. Kim and Congresswoman Maloney. That meeting presumably was for the purpose, according to appellant, of Ms. Kim either directing or approving of Ms. Maloney issuing the statement that...
Well, we don't, I mean, it may not have been a meeting, but we do know that there was some interaction.
All we know, and this is this is appellant's record, let's remember, this is what they submitted to the trial court. All we have is a photograph taken at a campaign event and which at least a minimum of 12, looking at the photograph, and 100, over 100 according to respondents'
A
papers
photograph
below.
that captured a moment in time.
Yes.
We do not know what occurred prior to the photograph being taken, during, or after the photograph being taken.
And the burden of establishing that there was a communication, a meeting, any conversation whatsoever, emails, written, oral, observed is on the...
It's certainly within your ability, presumably, if you presented an affidavit from the Congresswoman that said, what I said on August 3rd, 22, had nothing to do with Ms. Kim, that would be the end of it, wouldn't it?
And I would submit, Your Honor, had plaintiff below submitted a statement that was based on anybody overhearing, witnessing a conversation between Ms. Kim and the Congresswoman, we would not be here today. They were unable to do that. It was their burden. It was plaintiff's burden to do it.
Without
On a motion to dismiss, it is not
Counsel.
defendant's burden.
That's the whole problem here is that we're dealing with a motion to dismiss.
Yes.
Not a motion for summary judgment.
Yes.
And the more issues you raise, the more questions.
Thank you.
Yes, thank you, Your Honor.
So, Your Honor, the main point that I would like to address based on counsel's argument is that he attempts to cabin this plaintiff's case or appellant's case to one single photograph. And that's just not the case here. You have to pay attention. I would implore the court to pay attention to the record from April 2021 all the way through August 20th, 2022. And when you look at the record as a whole, drawing all inferences in favor of the appellant plaintiff here, you see that there was a you see that there is a republication, and that it was reasonably foreseeable based on respondents' conduct and behavior, both in the spring of 2021 and then subsequently in August of 2022, and the dormancy in between, when this campaign between Congresswoman Maloney and Congressman Nadler and Ms. Maloney was occurring, nothing was ever mentioned. Unless you have any other questions, I'll stop there. Thank you.
Thank you. Thank you both. Gibbs v. Manhattan Democratic Party.
I'm not in on the joke.
Yes, okay. Whenever you're ready.
Good afternoon, Arthur Schwartz for the appellant Eddie Gibbs. I know you've read the brief. This is an action to void an election of 2 district leaders, which the county has refused to recognize, and you have already ruled that the candidates that were elected cannot force the county to do that. So it's an interesting context that we're in here, because, but there are some important legal issues that need to be addressed. There are 2 issues. The first is Section 2106(4) of the election law says that members shall hold office until the next election at which members of the committee are elected. So the election was in June. This county committee meeting was, this divisional meeting of the county committee was in August, and for whatever reason, the people who were notified of the meeting and the people who were asked to attend the meeting were the ones who were elected the prior year.
June of 2022.
The prior year. So they weren't people who, the statute is pretty clear, members shall hold office until the next election at which members of the committee are elected. So the first point we made that the judge below didn't discuss was that the people who were present were not the proper people. The people who were notified were not the people who were elected that year.
So, counsel, I'm looking at Bauman.
Which?
Bauman versus Fusco, the case. And it says that upon the election of successors at the primaries, this is county committee, upon the election of the successors of the county committee members at the primaries, the outgoing members were no longer empowered to exercise functions in substantial matters. Is that applicable here?
That's our point. That's exactly our point, because this meeting, they were electing a district leader. And I know all of you, once upon a time were civil court judges. I happen to be a district leader. And district leaders, at least in terms of the judiciary, play a very important role. They play other important roles as well. It's a substantial issue of who's going to be the district leader where there's a vacancy. So that case stands exactly on all fours with
What
that.
powers or power do outgoing members have once the primaries have taken place?
None. They have no power because they're elected until the next election at which members of the committee are elected. They serve until, they shall hold office until the next election at which members of the committee are elected. That
Counsel,
election,
when this divisional meeting occurred, had the elections for 2023 been certified already?
yes. They were in June. This meeting was in August. The Board of Elections certified probably somewhere around the first week of July. So the wrong people were notified and the wrong people were present. The second issue that the judge spent a lot of time on was how many people could constitute a quorum. Now, according to the judge, 5 people could constitute a quorum, even though there were 84 seats in that district. He applied the wrong section of the election law because he applied a section of the election law. He applied a different section of 2104, whereas section 2-100 says that for all other committees, not the county committee, this was not the full county committee, this was a divisional committee, and I cite cases where they have city ones, town ones, whatever, they get groups together, the Democratic Party rules are the ones that apply. And what the rules say is that a quorum is 20% of those required to be elected, not 20% of those.
That's what the party rules provide, right?
That's what they were, right, required. The judge said 20% of those elected.
25% is what the judge said.
Or 25% of those elected. But the Democratic Party rules, which is what applied to a subsection of the county committee, say 20% of those required. The total required was 84. There was only 13 people there that didn't make the 20%.
It should have been 17. Should have been 17.
Should have been 17.
Quorum was 17. But what he did was, what the judge did was, he stated that 2-1043 should be read together with Article 4 of the party, 4B of the party rules.
2-1043 is about the county committee as a whole, which is a county-wide body. 2-100 is about other subsections of the county of the Democratic Party creates. So this is a divisional committee. The law says, and there are other cases that I cited in my brief, that various divisions, committees of the Democratic Party are not governed by, they're governed by the party rules. They are not governed by any section of the election law because the election law gives the party the power to set up any committees however it wants to do that. The Republicans don't have parts, the Democrats have parts. They can run those parts any way they want to run those parts. Actually, the Democrats have subparts of parts. We have, the one assembly district part A, B, C, D. That's the way the party decides to do it. That's the party rules. Then say how many people make a quorum, and to apply it his way and have 5 people be a quorum is pretty absurd.
Thank you.
Good afternoon, Your Honors. I represent the New York County Democratic Committee. The county takes no position with respect to the dispute between the candidate parties. Our concern today here is that we want to prevent bad dicta from becoming bad law. And just correcting that, what is quorum for a divisional committee meeting? To be clear, in accordance with the state election law, New York County Democratic Committee has a rule as to what is quorum for a divisional meeting. And that is 20% of the members, not this calculation that Judge Nervo came up with, which is 25% of 20%. As was already stated, this was a convoluted layering.
So you agree? You're in agreement?
I would agree with him, yeah.
You have no opposition?
I don't have an opposition to that. Just wanted to be very clear. The big concern here is that this case essentially will be moot in a few months because this position for the district leaders will be filled in the June primary. The concern here is that this bad dicta could become bad law with regards to quorum and can disenfranchise future people who want to get involved in the political process. That's the party's concern.
Allow me to ask you, what power does a successor, what power does an outgoing member of a divisional committee or a county committee have upon the election, after the elections, after the primary elections?
To be fair, Your Honors, the county party has taken a no position to the arguments that are being made between the parties.
You don't want to say.
And to be fair to the parties that are disputing, because again, we have two factions that are, two factional parties that are disputing things. And that's their right to do so. We have fantastic judges in front of us who are well skilled in that. And the party wants to be very clear to stay neutral so that if two factioning parties have an issue in the future, that they know that the party is going to be fair and let them fight, let them have their day in court and let the court decide. Our concern here today is specific to the fact that our rules be protected. Election Law 114 says, as Mr. Schwartz said, that the parties are allowed to create their own laws for their own rules to manage their political unit. We have those. The fact that the lower court made a mistake in saying that we're going to compound the quorum and requirement needed for the creation of the county divisional, the county party, and then compound that and then make some sort of mathematical equation with the actual rule for quorum is what we have a big concern with.
So that was 2 minutes and 15 seconds.
I promise
I gave
I'll
you
never
2
say a minute
minutes.
again.
I gave you 2 minutes, and then you wanted 90 seconds, and then you go over the 2 minutes.
Okay, next time I'll ask for 2 minutes.
There's no next time.
Thank you, Honor.
Thank you. Thank you both. Take care. BML Properties versus China Construction.
May it please the court, Maura Monahan from Debevoise and Plimpton LLP on behalf of the appellants. Your Honors, this case is brought by a plaintiff, BMLP, who used its power as the sole voting shareholder of BML to cause it to file for bankruptcy. That was their choice. They did it unilaterally. They concealed it from their co-investor. And the consequence was that they wiped out not only their own equity, but that of my client, CSEC-B, the minority shareholder. CCA Bahamas, a separate entity that was not an investor but the construction manager of the project, ultimately successfully completed the project at a cost only 3% over the original budget. The crux of BMLP's complaint is that when BML was dissolved, it lost the entire value of its investment, but so did CSEC-B. BMLP did not suffer a disproportionate loss. BMLP urges that BML was liquidated because of appellant's supposed delay of construction. We submit that's not true. It was BMLP, but...
Do you think you could slow down a little bit?
I will, Your Honor. I took the predecessor to heart.
It's a lot. It's a lot.
It was BMLP that overloaded this project with over $2 billion in debt and overspent in myriad other ways. But that almost doesn't matter because what BMLP is accusing us of is causing harm to BML. Where a shareholder like BMLP contends that a defendant's conduct supposedly injured the company in which it invested, that's a classic derivative claim under New York law. That was determined by this court in cases like Serino versus Lipper, where the court held that, quote, the lost value of an investment in a corporation is quintessentially a derivative claim, close quote. And this court has repeatedly reaffirmed that principle, including, for example, in 2022, in Mohanini versus Charney, in which a panel including Justices Weber and Friedman affirmed the dismissal of the claim of a minority investor in a real estate joint venture, which was, just like BMLP, arguing that the co-investor had failed to act in the best interests of the venture. That was a derivative claim. BMLP attempts to get away from that principle by pointing to $700 million received not by CSEC-B, but by CCA Bahamas. But that was not in any way a return on CSEC-B's minority investment. It was consideration.
Is it a derivative claim because BML Properties is a party to the investor agreement? And don't the provisions as set forth at page 87, 88, 89 of the record, doesn't that permit the BMLP to sue on its own behalf? It's not truly a derivative claim because it itself is a party to the agreement.
Your Honor, I would submit that that exact issue was addressed by the court in Miller, where the court said the issue is not whether a plaintiff's name appears in the agreement or it's a signatory to the agreement or it has other rights under the agreement, but to whom the particular obligation at issue is owed.
So don't these particular obligations belong to the plaintiff itself?
No, they don't. So BML, which is the company in which BMLP was an investor, BMLP, the plaintiff here, is not the resort developer. It is a shareholder in the resort developer. Section 4.7 of the investors agreement states that the CSEC-B representatives appointed to BML's board, shall be appointed to assist the company and are required to act in the best interests of the company.
But then 4.10 of the agreement authorizes the plaintiff to bring suit individually.
But not for breaches of obligations that are owed to BML in the first instance.
But we still have an independent duty, right?
We do not have an independent duty, and in addition to that, you also have to look at who suffered the harm. If you read pages 16 to 17 of the opposition brief, you will see it's a veritable incantation of harm that supposedly befell BML. And remember that here, it's not a technicality to look at the direct derivative distinction. BML settled all of its construction-related claims in the insolvency proceeding in the Bahamas. BMLP does not like the way that turned out, and that's why it's here trying to step into BML's shoes. But there's no getting around the fact that all of the harm went to BML. It's also the case that the provision on which they rely, Section 4.7, is an operative provision with respect to CSEC-B's representatives on the board in their capacities as such. It is not an obligation of their employers, the other companies like CCA Bahamas, to act in any particular way. And to give your honors an example of that, the CEO of Marriott is currently a board member at McDonald's. Like the best interest provision, that director has a duty of loyalty to McDonald's because it sits on the board. But if a shareholder of McDonald's sued Marriott because Marriott was not being run for the benefit of McDonald's, that would be a derivative claim. The court below also independently erred in failing to grant summary judgment dismissing the lost profits claim. There's no dispute that the Baha Mar Resort was intended to be a brand new mega resort and had no track record of operations, let alone profitable operations, that would permit such an award under New York law, including the Kenford case from the Court of Appeals. To the contrary, prior to CCA Bahamas' involvement, the principal of BMLP had spent years trying to get it off the ground with Harrah's. That ended up in a fraud case that ended up before this court, pursuant to which he was ordered to pay Harrah's $12 million.
Thank you. You have time on rebuttal.
Thank you.
May it please the court, good afternoon. My name is Jacob Buchdahl. I'm with Sussman Godfrey LLP for the respondent. I think that the court has already focused right in on the heart of why this is a direct claim. First of all, if you look at 4.7, it doesn't just talk about acting in the best interest of the company. It also talks about how these obligations are for the benefit of other investors in the company. And that is none other than the plaintiff BMLP here. And as I believe Justice Friedman pointed out, Section 410B4, which is at page 89 of the record, specifically states that BMLP has the right to bring its own lawsuit for its own damages. The investors' agreement in this case puts the plaintiff in privity with the defendant, just like the founders agreement in U-Trend, which was this court's decision in 2020, put that plaintiff in privity, which is what makes it a direct claim. There's also an independent reason for finding it's a direct claim, and this is the basis that Justice Scarpula found back 5 years ago, a basis that was affirmed already by this court, and that is that our client, BMLP, suffered a disproportionate loss. With regard to lost profits, there was nothing particularly speculative about this resort. In fact, there was a resort just like it right down the beach called Atlantis.
Are they really the same, though, if one was completely built and one wasn't?
Well, Your Honor, this resort was actually 97% complete at the time of the breach and the fraud. I'm not giving you that number. That number is in a footnote in defendant's own brief. This resort was almost entirely built.
It's basically uncontested, I believe.
I'm sorry, Your Honor?
It's basically uncontested that it was 97% complete.
That's correct. So this is not some stadium like they were trying to build up in Erie County in Kenford, where they hadn't really even broken ground and were hoping they could turn it into the Astrodome. This is a resort that was nearly complete. And by the way, we know it works. We know it's profitable. You can go visit there right now. This is a beautiful resort in the Caribbean. It is just as profitable as Atlantis. And if you look at our lost profits model, which is in the record at pages 1979 to 1996, you can see how carefully our expert constructed a bottom-up comparison. Now, lost profits
Counsel,
haven't been...
What about the provision in section 1110? It said that the parties expressly waived any punitive, consequential, incidental, exemplary, statutory, or treble damages. So don't you have a problem there?
Respectfully, we do not, Your Honor. The only question would whether lost profits would be consequential damages. They would not be consequential damages under this contract, and that's because they don't require some further additional consequential contract to lead to the profits. This investors agreement itself would generate profits for our client, so they're not consequential. There's a further ground at which they could be awarded, which is the wrongdoing by defendants. Both of those theories are sufficient, certainly, to go to trial. As for lost profits, of course, as the trial court pointed out below, we still bear the burden of showing that the parties contemplated that lost profits could be a remedy. That hasn't been decided yet, but certainly there's enough evidence that the parties were talking about lost profits directly in the contract itself, and I would point Your Honors to section 4.10b3, which specifically talks about some profits that we would be entitled to if we had to fund additional amounts. There's not only contractual language talking about lost profits, but also the very nature and purpose of this contract was all about the profits investors would receive. So in light of that, in light of the fact that this was not particularly speculative given how advanced the project was, given the comparable resorts, we should be able to present that model at trial this August. If there are no other questions, we'll rest on our papers.
Thank you.
Thank you, Your Honors. I think you'll find when you look at the investors agreement that there's been a little bit of a mixing and matching here. If you look at section 4.10.4, it says in the event of a default by China state under any of the sections 4.10 A1 through 5, Baha Mar or the company may seek to recover damages against China state. The obligation on which they're resting this case is not an obligation of China state, but of the China state representatives in their individual capacities, just like that board member from Marriott in 4.7, which is not included in the provisions listed here as giving right to a direct cause of action. And the Miller case tells you to look at the language of the contract and not look simply at arguments that they're a signatory or there are other provisions of the contract that apply to them. With respect to lost profits, there is again a mixing and matching problem. The question under New York law is not whether the parties thought there could be profits, but whether the parties contemplated that a minority investor putting in $150 million would be liable not only for the loss of its investment, which all investors take the risk of, but for consequential damages in the form of lost profits to come from years of operation of the resort.
So your argument is that this would be consequential damages?
Yes, because under New York law, where the damages at issue are to come from third parties, there is no universe, even BMLP's alternative universe, in which they were expecting as a result of this contract that CCA Bahamas or any of the appellants would be paying money directly to them. The money would have come from hotel guests, casino patrons. Under New York law, that is consequential damage because it's the result of business arrangements with third parties. The contract, which was between sophisticated parties, is crystal clear in Section 11.10 that a whole host of damages, including consequential damages, are not available. Sorry, Your Honor.
Counsel, kindly, could you address your counterclaim with respect to the plaintiff's duty under Section 4.7 to provide CSCEB?
I say CSEC-B because even if you've read tongue twisters to your children, CSCECB is
Yeah, I
too
can't
hard.
do the letters. Access to the company's books and records, is that
Sure.
one of your counterclaims?
That is one of our counterclaims. We had submitted requests for the books and records. There's no question about that. We had submitted those requests pursuant to the investors agreement, and the requests were not complied with. And part of that was because as the...
Not to this day.
Well, after the Bahamian winding up proceedings...
That was it.
That was the end of BMLP's involvement.
Thank you.
Because BML was dissolved. Thank you, Your Honor.
Thank you. Thank you all. People v. Travis Woods. You may proceed.
May it please the court, Matthew Bova of the Center for Appellate Litigation for Mr. Woods. 3 years of delay following 3 hung juries was too long, violating the speedy trial right. Wiggins and Taranovich instruct us to focus on the basis for the delay when we have a length of this substantial nature, which is 3 years.
And what was the basis of the delay here? Was it not the parties trying to work something out, or?
All the basis for the delay, as far as the prosecutor's affirmation in response to the motion to dismiss at paragraph 14, is that they were having meetings for the bulk of the delay. Now, meetings cannot justify 3 years of delay. And I think it's very important to focus on what the prosecutor does not say in that affirmation.
The meetings were happening with defense counsel, right?
That's not what the prosecutor's affirmation says. The prosecutor says, quote, the bulk of the period between the last mistrial and the instant trial have involved a series of meetings held within our office at the request of defense counsel, who sought a dismissal of the charges in the interest of justice.
So
right, so
I'm sorry.
Go ahead.
There were no ongoing meetings?
Well, that's what the prosecutor states.
I'm asking you.
Well, according to the prosecutor, but defense counsel says over and over again on the record, he says when he actually appears, the prosecutor often did not appear at all.
Just answer the question, counsel. Was that bogus or was that true?
No, and as far there's at a minimum there's an issue of fact on that, because defense counsel says there is no basis for this delay in his motion. He says over and over again, I've tried to contact them. I don't know.
Let's back up. Let's try to get the question. The question was, is it correct that there were meetings going on between defense attorney and the prosecutor concerning the case, specifically whether the people would in fact retry the defendant? Whether or not the prosecutor or a prosecutor appears at a calendar call does not mean that meetings were not taking place. So from your perspective, in terms of your review of the record, were these meetings taking place?
No.
Okay, thank you. So now my question is, was the defendant incarcerated or pending sentence during this 3-year period?
Yes, he was incarcerated on the first trial verdict.
And so on the first trial verdict, had he already been sentenced to 9 years?
Yes, Your Honor.
Okay, so he's serving 9 years, and now we have a 3-year delay in the prosecution as to the other charges. Is that correct?
Yes, Judge.
So where is the prejudice given the fact that the defendant would be incarcerated anyhow?
So the prejudice is in the presumptive prejudice that comes from a delay of this length. The fact that he is incarcerated on another charge under long-standing Court of Appeals law, Singer, Winfrey, Prosser, and also Smith v. Hooley from the Supreme Court, all those cases very clearly say the fact that someone is incarcerated on another charge does not justify substantial delay. And that's because the only...
Aronovich, Bradshaw, Dessel, they all say that you do consider prejudice and whether there is any prejudice to the defendant based upon this delay.
Well,
Is your argument preserved?
Yes, Judge.
Really?
Yes. So counsel makes a motion to dismiss. He specifically says at paragraphs, and just to cite to the court, paragraphs 10, 11, and 34 of his affirmation, he specifically says, the prosecution would routinely not attend the calendar calls or send a note concerning their intentions, rarely gave a reason for their lack of readiness. Defense counsel had personally made several unsuccessful attempts to contact the prosecution to determine the status. The record bears that out. Time and time again, the prosecution is not even present.
What do you say about the people's claim that they acted in good faith and that they were investigating and deciding whether to re-prosecute? What do you say to controvert the people's assertion that they acted in good faith?
Well, the first thing is to the extent that any of those facts, if credited, would defeat the motion, that justifies a hearing, because counsel clearly is saying there's no basis for this.
Well, what do you say, what do you allege in terms of the people's good faith?
Well, good faith or bad faith is irrelevant under Wiggins. Wiggins very clearly says that in the context of post-indictment delay, the good or bad faith of the prosecution does not matter. But I think Your Honor's question gets to a really important point, and Your Honor referenced an investigation. I think that this would be a much different case if that's what the prosecutor had said to justify the delay. That, for example, defense counsel had cited a new witness or a new lead, and the prosecution had sent the police out into the field for an investigation. But that's not what the prosecutor says. That's why this case is different, because here, all the prosecution says is, we're having meetings. We're thinking about whether to bring this case forward. The speedy trial clause does not allow the prosecution to think about it for 3 years. That is particularly true after the case has already been brought to trial for three times. Mr. Woods had been indicted in 2008, and the case does not get to the...
That's a circumstance which would support the people being very thoughtful about what they're going to do next, having failed to achieve a conviction after 3 times.
Well, they can think about it, Your Honor, of course, but they cannot think about it for 3 years. If the prosecution had not kept the court in the dark, as the calendar calls show, prosecution simply just is not even telling the court what's going on. They waffle back and forth as to whether they're actually 100% sure they're going to decide the case. We can all be certain that if the prosecution had said, Your Honor, we're having meetings simply to decide whether we want to go forward, the court would have said, I'll give you a month. I'll maybe give you 2. But no court would ever say, I'll give you 3 years, because the prosecution has the obligation to move forward. And part of that obligation is making a decision about whether you're going to retry the case. And that didn't happen here.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court.
I would like to start with the preservation issue as to that. Did the defense at any time attack or argue or oppose the prosecution's affidavit or statements that they were attempting to investigate or figure out how they were going to proceed?
There was no reply given. I mean, certainly parts of the whole constitutional speedy trial claim are preserved and parts are unpreserved, we allege. And that includes that when the people say that these meetings were done at the request of defense counsel for defendant's benefit, that when the defendant did not rebut that in a reply, that he shouldn't now be heard to say, well, we don't actually have more information about what's going on with these meetings, how often they were, who they were with. And so those, to the extent that that is what the defendant is claiming is the error, that's unpreserved and doesn't require a hearing to resolve.
Did the defense ever state that the people were acting in bad faith or not acting in good faith?
I mean, there was some suggestion at various times that the people waited for Raymond Glover to pass away, which I don't think the court took very seriously, and I don't think that appellate
I'm not sure why the people would wait for what I would term perhaps as a star witness to die prior to trial.
No, I agree, and I think that's why appellate counsel doesn't raise that as
So what do the people say which supports this investigation?
about what's the.
What do the people say which supports that there was an ongoing or further investigation?
Well, we have the motion, the opposition, which states that these meetings were occurring, and then we also have some record support for that based on
Does a meeting equal an investigation?
So I don't think a meeting equals an investigation. I think that what's most likely, and there does appear to have been some new investigation based on the new witnesses that are testifying at the fourth trial, but I think that deciding whether to retry a defendant a fourth time is very rare and a very weighty decision, whichever way you come out, whether you're going to try a defendant a fourth time or whether you're going to dismiss a charge where the people are convinced that the defendant murdered the victim in cold blood. Either way, that's a very serious, weighty decision that can understandably take time. I think it's clear that the people aren't.
It takes 3 years.
I think the people aren't blameless here, and we're not arguing that this probably should not have taken 3 years. But when you're taking this type of decision, I think it's reasonable to take a significant amount of time. And certainly it would be better if the people had arrived at these calendar calls and gave more information about what occurred in these meetings. But just because that isn't always there in the record doesn't mean that these discussions aren't happening in the background. And even if all what defendant's counsel is saying is true, is that the 3 years, and it's not quite 3 years, it's closer to 32 months that I think between those meetings are going on. Even if all of that is attributable to the people, and you can look at Dizelle, where that delay was largely attributable to the people, but the other factors were so strongly weighing against a constitutional speedy trial violation that there wasn't a violation. And that's exactly what happened here, where there is a lengthy delay, but the reasons are reasonable, and even if you put aside that, you have an extraordinarily serious crime, the most grave offense at law. You have a defendant who is not prejudiced. Presumptive prejudice can be overcome by the specifics of the case.
Ultimately, at the fourth trial, you do come up with a new witness, do you not?
I'm sorry, I missed the first part of your.
Ultimately, you come up with a new witness at the fourth trial, Lindo, right?
How did the?
You come up with a new witness
we
at the
did,
fourth trial, Lindo.
What's who?
What's the explanation for why this witness wasn't there before?
I don't think there is an explanation given on the record. I mean, I think that based on what happened at the trial, we can see that Lindo obviously wasn't a cooperative witness. And maybe at the first 3 trials, a prosecutor who tried that case understood that that witness was not going to be a cooperative witness and chose not to rely on it. Because ultimately, I think
or maybe you couldn't locate the witness.
That could have been possible too. Your Honor, if I could just have 1 minute briefly to discuss the ineffective assistance and why those claims are barred.
1 minute.
So I think it's very important to ground any discussion about the ineffective assistance claims in the procedural posture of this case, because there was a 44010. It was done with counsel in a 100-page motion. That was denied. There was a hearing, and then the defendant sought leave to appeal from this court, and a justice of this court denied that claim. And that should foreclose all review of those identical claims. And really what's left is about one claim that Eric Calvin testified that defendant had a gun previously, that Detective Stratford had said that there were snitches get stitches on the wall, that there was a 2012 Rikers call that was fairly innocuous, and then an instruction about Glover's credibility being harmed by him testifying with an attorney. None of those, I think, carry the day, and any genuinely new claims should have been raised in a 440 motion.
Thank you.
But the problem is, Justice Friedman, is that the prosecutor does not say that the delay is based on Lindo. The prosecutor was clearly very interested in Lindo because the prosecutor aggressively tried to impeach him at the fourth trial. But the prosecutor didn't say, this delay was based on me seeking new witnesses. This delay is based on me seeking new evidence. That's critical because it's the prosecutor's affirmation under 21045 and the record that's going to control. And where the prosecution does not conclusively refute the no good clause claim that defense counsel specifically pleads and that has record support. Under Allard and under 21045, under those circumstances, at a minimum, a hearing is required because there's an issue of fact. But I just want to make it very clear that as the prosecution is acknowledging, the affirmation doesn't say anything about investigations. All we really have here, and the record bears this out, is that they're pondering prosecution. They're pondering whether they should move forward. 3 years of pondering is not permissible under the Speedy Trial Clause. And this is preserved under Allard and under 21045. Defense counsel makes specifically pled allegations of no good cause. The prosecution, and specifically says, effectively preempting the prosecution's affirmation, they will not be able to offer.
I have to ask you again, counsel, did you submit a, did you preserve this in, did you submit a reply arguing that the people's proffered reason for the delay was wrong?
No, there was no reply submitted, Your Honor, but that's not required under Allard. Allard, the Court of Appeals decision in Allard specifically holds that in order to preserve a claim, one need not file a reply. And the same thing is true under 21045. Under 21045, when defense counsel pleads allegations and the prosecution does not conclusively refute them, as here, then what is required is a hearing. But Allard specifically rejects any requirement of a reply, instead saying that the opening motion papers can substantively plead the factual allegations. That's done here. At a bare minimum, there's an issue of fact that should go to a hearing on remand.
Thank you.
Thank you.
Sanders v. Cooperative, Rebel Bank. Whenever you're ready.
Good afternoon. My name is Jeff Little. May it please the court, I'm here on behalf of the appellant plaintiff, James Sanders. This is for all of the discussion in the briefs, this is a very simple case. It's not a case in which any of the decisions of this prior court are in any way being argued for change or repudiated in any way. This is a case that deals with a simple, very simple issue, which is, should summary judgment have been granted in this New York City human rights law, age discrimination action?
So, counsel, your client was 55 when he...
Pardon?
Your client was 55 when he was hired. He was 57 when his job was terminated. He was hired as a consultant to deal with the whole pre-registration arrangement.
Actually, I think in the record it's pretty clear in his hiring and in his, both as an employee and as a consultant, that there was...
So if he's hired as a consultant to help the defendant obtain a license as a swap dealer, at the point where that is pretty much completed and he doesn't have experience with the part that comes after that, which is post-registration business as usual, called BAU, where do we stand? What happens?
Well, let me just clarify this. He was engaged as a consultant through a company to, as you say, among other things, to consult on the swap dealer. He was brought in, interviewed by Mr. Candido, who was terminated before him. He was one of the three people who was older than Mr. Sanders at the time. In August of 2016, a few months later, he was offered full-time employment with a job description that in part, only in part, is set forth in our opening brief, which describes the many different aspects of his employment, which did not include simply trying to get a registration under the Dodd-Frank Act for a swap dealer. His role was, at the time, and throughout the entire time period until he was terminated, was to do what later became this so-called BAU. The regulations requiring licensing, if you went over the, I guess it's sort of a funny.
But it was my understanding that your client did not have any experience as post-registration business as usual.
Well, that's not true, because the post-registration business as usual was the same as the pre-registration business as usual. He had extensively supported the front office, and he had extensively done all of the
For pre-registration.
pre-registration, yes, because they were allowed to do $8 billion a year in business.
Did he not testify, or did he not state that, I thought it was undisputed that he did not have any experience in post-registration compliance?
That is definitely not.
But he didn't have experience with the Volcker rule compliance, did he not?
No, but the Volcker.
He didn't have experience with that, correct?
That's correct. And when Mr. Vitiver testified after he joined the firm, the highest percentage at any point in time that he performed Volcker rule compliance was 30%. Catherine Lamper, who was the boss, Mr. Sanders' boss, and remained in charge, had done the Volcker rule compliance. She began to primarily function in working on what Mr. Sanders had worked on. So it wasn't even a extensive amount of work that was done on Volcker. In addition to that, there's a number of issues that are discussed in relation to whether or not Mr. Sanders would be able to perform Volcker rule compliance. Let's start out with the fact that he had been practicing for over 30 years in this compliance area, primarily worked at 2 major law firms, worked at the CFTC,
So, counsel,
and he'd been the chief compliance officer.
So in these cases, the issue is whether or not there is a genuine issue of fact as to whether age was a motivating factor in your client's termination. Here we have evidence that your client did not have experience in the Volcker rules, yeah. Also, he had limited experience in post-registration swap, and that he had no experience whatsoever in terms of the Volcker rule compliance. So given that, why isn't that sufficient to show that the basis for his termination was not related to his age, but rather related to the fact that he did not meet the qualifications, requirements for the position?
Well, a number of things. Okay, the issues that you're describing were already being taken care of. Mr. Vitiver had been hired without Mr. Sanders or anybody else knowing it, and he was going to be starting to work on the Volcker rules stuff. The post-registration work was something that, in fact, in a pre-registration capacity, Mr. Sanders had been doing, but it didn't go away. And when he left to replace him, the company hired 4 individuals. The closest in age to Mr. Sanders was 16 years younger than he was. One of them was 26 years younger than he was. So there was evidence that indicated that this was a false issue, and of course, under this court's decision in Bennett, this court's decision in Melman, and basically the interpretation of the 2005 Act as the City Council put forth in 2016 we're dealing really here with a mixed motive case. And as a mixed motive case, if anyone, this is what...
I doubt that Melman gives you support for that proposition.
Pardon?
I doubt that Melman gives you support for that proposition.
Well, that's the funny thing, because as you can see, I know you wrote it, but as you can see in the opinion, on page 2 at the bottom of the opinion, the trial judge truncates a quotation from Melman that you had you'd written, if I can just...
You can find it on rebuttal. Thank you.
Pardon?
You can find it for your rebuttal.
Is my time up? I'm sorry.
A while ago, but that's
Okay.
okay.
Good afternoon, Your Honors. May it please the court, my name is Diana Gomprecht.
Let me ask you a question. So we know that the plaintiff's job performance wasn't an issue.
Correct.
Right? But we also know that the decision to terminate him was made by 3 people who were younger than he. One was 43, one was 49, one was 34. And we know that his job duties and responsibilities were distributed amongst 4 people. One was 41, one was 34, one was 35, one was 39, and he was 57 at this point.
Yes.
So in your view, how does this comport with Bennett, where the 4th element is whether the employment action occurred under circumstances giving rise to an inference of discrimination? Is there an inference of discrimination here?
Thank you, Your Honor. Very good question. No, there is no inference of discrimination here. The assignments that went to other people went to people who had been at the bank already.
Who'd been what?
They were already employed. Oh, okay. I'll be louder. They were already employed by Rabobank and had been in the compliance department longer than Appellant. And I just want to correct something that counsel said at one point. He indicated that 4 new compliance individuals were hired, and that's not what the record shows. 3 individuals in compliance who took over some of the responsibilities of Appellant had been there for years.
But there was a new hire.
There was a new hire, correct, Your Honor.
And how old was that new hire?
He was 41, and his position was new, and it was something that
It
Appellant...
was a lower pay or grade position too, correct? It was a lower pay grade.
Exactly right, Your Honor.
And a different title.
Correct. Mr. Sanders, because he had such an elevated level of expertise in swap dealer compliance registrations, was paid for that. He was actually among one of the highest paid employees in the compliance group, recognizing his expertise. After 2 years of working towards gaining a license, it was determined by many people in the department, including the chief compliance officer, that his expertise was no longer required, that obtaining the license was imminent. In fact, Mr. Sanders conceded this as well after he was terminated. We have several quotes in our brief.
Well, he stated that while the company stated, the bank stated that it was imminent, it actually did not occur for a year.
Yes, you're right, Your Honor. So I think at the time that Mr. Sanders was let go, everyone was under the belief that the license would be acquired the following month in May of 2018. The timing of when a license is acquired, such as this, is really an issue for the business people. So compliance assists in the process, but they're not involved in the business decisions. And so markets, for whatever reason, had a delay in the process. But there is undisputed evidence in the record that Mr. Sanders' departure from the bank had no impact whatsoever on the timing of when the license was acquired. And that's really important because everyone had decided that his expertise, his role, which he was being paid handsomely for, was no longer required, had nothing to do with his age. So there's sort of this disconnect, right?
Was he paid more than his boss?
So there are several levels. His direct boss, he was paid more because the bank recognized that they needed someone with this high level of expertise. And there weren't many individuals out in the market who had done swap dealer compliance, registrations to the extent that appellant had. He truly was an expert. And so they were willing to
The
pay.
plaintiff was a consultant. Were these
Yes.
other people consultants too?
The others were employees. During Mr. Sanders' time there, he did ask for another consultant to be hired to assist him, and they gave him that support. So they really did nurture this environment where he was treated at all times with dignity and respect, commensurate with his levels of experience and expertise. When it was determined for business reasons that that was no longer required, and that the others in the group, which had already been dealing with the swap dealer business at a de minimis level, there was no basis to continue his employment at that point, and that's what the business decided.
And does the hiring of that new employee change this? In other words, if his work was distributed to people who were already employed,
yes,
does the hiring of somebody new change the argument?
No, Your Honor. I think, first, appellant interviewed that employee. He actually recommended someone younger for the position. So the bank ultimately hired someone who was 41 years old. Appellant had recommended somebody who was 35 years old. That just goes to show the bank is making legitimate business reasons based on the information it has before it and is not factoring in age. So Mr. Vidaver's role was very, very different. As noted by Your Honor, different salary pay band, different title, more of a generalist role. They really needed help with the Volcker Rule compliance. It's undisputed that appellant had no experience with the Volcker Rule, and that's really important because in the record, which I know Your Honors have already before you, you can see that compliance is discussing this need. We need that. There's a gap in the compliance group on the Volcker Rule, and so they start interviewing people, and Mr. Vidaver fits the role perfectly. There's no connection really between appellant's departure and Mr. Vidaver's, except for the fact that once he left, as in any job elimination, his duties were spread out.
So during the reassignment, were any individuals terminated who were younger?
So there was a RIF, a reduction in force that occurred that you may remember from our briefing. Both parties discuss it. It was called Project Columbus. During that time, there were 14 members in the compliance department who were terminated. Some were offered different positions within the company at a different location. Of those individuals who were terminated, 3 of the 14 were over 50. The majority were in their 20s and 30s. So I think the record is clear that this is a company that is making business decisions solely on the basis of what it has before it, its business needs at any particular time, and is not factoring in age. And again, there was nothing ever said to appellant regarding his age where someone could infer that there was any kind of animus. The same chief compliance officer who made the decision to hire appellant also approved the decision to terminate the role. So we also have the same actor principle. There are other members as well who were involved that don't overlap in both decisions, but any major decision like that has to be approved by the chief compliance officer. And in this instance, who is over 40, and I know that we're not in federal court, but just to give you a sense of the ages of some of the members here who were making these decisions, approved both decisions. And it was purely financial, and I think the record is undisputed that the bank was going to save money, given his salary. Thank you so much, Your Honors.
Thank you. I'm sorry, counsel, when I interrupted you, you were looking for
Yeah, I just wanted to reference that in Melman, which I should mention is a very different case because it's dealing with retaliation claim. And retaliation claims, just even conceptually, are extremely different. Melman had his job. He was continuing making at least $550,000 a year. And he'd been there a long time, and there were a lot of negative things, at least apparently negative things about him. There was nothing negative about Mr. Sanders. There was one adverse employment action here, and that was he was terminated. And Melman is, as I said, the opinion of the court below truncates a quotation ending with the words different mixed motive framework. After that, there is a section that runs probably 40 lines of text explaining that and completing the sentence, none of which is demonstrated in the opinion. There's no ellipsis there saying that this stuff has been omitted, but it has been. I don't find anything in Melman that would in any way say that the mixed motive methodology that was described in Bennett was no longer applicable. And that mixed motive is if any of the reasons that were given, any of them, is false, misleading, or incomplete, then you should have a trial. And it says that it would be the rare circumstance otherwise. I can tell you right off the basis of it that this cost-cutting thing was not a reason. There was no discussion of it ever. It came up as a post-litigation defense, and the cost-cutting formula that the judge used in the opinion runs up to a 15.
You said in your brief at page 8 that the compensation levels at the respondent were inextricably correlated to age. For example, Lampert, age 34, earns $75,000 years less than the plaintiff, which would be $200,000 versus $276,000.
Correct.
How did that help you?
And the reason that we address that is because it has traditionally been held that you can't look at the two things together, that is compensation and age. In this case, ironically, it was inextricably intertwined. And so even with regard to that, this trillion-dollar bank, this minuscule $15,000 a year, without including some of the other costs that were added when Mr. Sanders was terminated, can't possibly have been a reason. Thank you.
Thank you both. People v. Robert Moore. Whenever you're ready.
May it please the court, Samuel Steinbach Pratt for the Office of the Appellate Defender.
So let me ask you this. The Moore indictment, the indictment in this case says, and the grand jury aforesaid by this indictment further accuses the defendant of the crime of persistent sexual abuse in violation of Penal Law 130.53 committed as follows. The defendant in the County of New York, on or about August 21st, 2018, subjected a person known to the grand jury to sexual contact, to wit, placing his hand on said person's buttocks without her consent. So under 130.53, the persistent sexual abuse statute, in order for the people to convict under that statute, they have to convict the defendant either of 130.52, forcible touching, 130.55, sexual abuse in the third degree, or 130.60, sexual abuse in the second degree. Now, if you look at 130.52, in order to convict of that crime, the first subsection of that statute talks about touching the intimate parts of another purpose for the purpose of degrading or abusing such person or for the purpose of gratifying the actor's sexual desire. No mention of that in the indictment in this case, correct? You go to 130.60, it talks about a person is guilty of sexual abuse in the second degree when he or she subjects another person to sexual contact, and when such other person is incapable of consent. It talks about an inability to consent as the basis of that you can get a conviction under this statute if the victim is not capable of consent. No mention of that in the indictment. So that leaves us only with 130.55, sexual abuse in the third degree. That, not to read the whole thing, is a person is guilty of sexual abuse in the third degree when he or she subjects another person to sexual contact without the latter's consent. So when you look at the indictment in this case, there is only one section which fits into the three possibilities that 130.53 permits. Why isn't that not a jurisdictionally satisfactory indictment?
So a couple of things in response to that, Your Honor. First, the defect with this count of the indictment is the same one this court already confronted in Hardware and Lacey, which is that the elements alleged are common to all three potential qualifying offenses. It's also, I'd note—
The elements alleged here are not subject to all three statutes. Only one of them can conceivably meet the statutory choice, and that's 130.55.
Well, I disagree, Your Honor, and let me just explain why. I think what Your Honor is picking up on is an argument that respondent makes in their brief, which is that, well, if they had intended to do something other than third-degree sexual abuse, they would have worded it differently. But respectfully, Your Honor, that's begging the question. It's assuming that the indictment must be valid, and so we have to read it in a way to make it valid. The issue with this is that the elements alleged are common to all three offenses. It doesn't distinguish between them.
Well, isn't the issue whether the indictment is invalid because the defendant doesn't know what he's being charged with? And how does the defendant in this indictment not realize he's being charged with 130.55?
Well, so if I may, Your Honor, the other thing I wanted to say is that I think Sanger also does make pretty clear— I'll just briefly say respondent's primary argument is that Sanger implicitly overruled Lacey. That's just not true. There's no conflict between the holdings of either decision. One thing Sanger does make very clear is that you can't have a jurisdictionally valid indictment based on requiring the defendant to sort of do the exercise you just went through and like rule out alternatives. It needs to be clear on the face of the indictment and within the four corners of the specific count precisely which qualifying offense is at issue, and the defendant can't be expected to go through a sort of ruling out alternative exercise. That's the people's burden in the first instance to establish. This court already considered identical language in Lacey and held that it was defective. There's no reason for it to do any differently here.
Thank you. So, counsel, here we're talking about the second count of the indictment?
Yes.
So under the second count of the indictment, subjected a person known to the grand jury to sexual contact, to wit, placing his hand on said person's buttocks without her consent. Is that correct?
Yes.
Then Lacey, it states, the defendant in the county of New York subjected another person known to the grand jury to sexual contact without the latter's consent.
Yes.
The difference between the two is that in this case, the indictment specifically states what the sexual contact was, placing his hand on said person's buttocks without her consent.
That's one difference.
What's the other difference?
The most important difference is Sanger. And this is the first panel to address Sanger, or to address the issue in Lacey after the Court of Appeals decided Sanger.
So Lacey went up to the Court of Appeals.
No, Lacey, it was not decided by the Court of Appeals. Leave was denied.
Leave, that's what I meant. Leave was denied.
Yes.
Okay.
Although I will say about that, I mean, 5 paragraphs of the defendant's leave opposition in Lacey. And, you know, we were with the same counsel for Lacey. We handled the leave opposition.
Bottom
leave
line,
conference was graded.
leave was denied.
Right.
Whether it's 5 paragraphs or whether it's 2 pages.
Well, I want to be clear about why leave was denied. The 5 paragraphs are referring to in defendant's leave opposition devoted to arguing that even if Lacey was wrongly decided, and to be clear, he made an argument about why Sanger and Lacey can be reconciled. But even if Lacey was wrongly decided, that the case did not present an important issue for the Court of Appeals review, including giving an appellate panel the opportunity to address the issue in Lacey with the benefit of Sanger, which had not happened.
So I'm looking at Sanger, and Sanger talks about the fact that the indictment must give provides the defendant with some means of ensuring that the crime for which the defendant is brought to trial is in fact one for which the defendant was indicted by the grand jury, rather than some alternative seized upon by the prosecution in light of subsequently discovered evidence.
Right. I think we can all agree that the indictment for this type of crime, we labeled it a parent offense, one that's defined by the commission of another offense plus some other aggravating factor, here the criminal history. We all agree that the indictment has to specify the underlying offense. The issue is how to do that. And so the Court of Appeals in Sanger was addressed with a materially similar statute when it comes to can you just say the statutory definition of persistent sexual abuse or aggravated family offense, which just says you committed one of 18 crimes plus you have this criminal history, or with persistent sexual abuse, you committed one of these 3 crimes with another criminal history.
But Sanger says, counsel, that it's not the defendant's burden to parse the elements of each qualifying offense or to infer what might be the crime charged based on the factual allegations. So don't we have a problem here?
No, that's exactly right. And that's exactly what defense counsel is asking, a rule that would require defendants to not just look at the statutory language and see if it does here is stating the statutory definition of third-degree sexual abuse fully describes that crime and no other offense. It says defendants, no, go and look and see, are there other offenses that even by reference to other penal law sections incorporate those same elements, and then see, well, maybe you might also be tried for that crime. That's just not how indictments have ever worked. And so what Sanger was doing was incorporating the long-standing black letter law that if you state the statutory definition of an underlying offense, that's sufficient. It was just saying that you have to do that for parent offenses by stating the qualifying offense, the definition of the qualifying offense in the factual allegations. And so there is...
What Sanger was saying is to take out the guesswork, right?
Exactly.
So you're not trying to figure out what is the qualifying offense, and it's detailed. Do you think that this indictment does that?
It does that. And the only thing I think that defense counsel really says that you could do more is say, you know, you can allege a statutory section number, you can allege the title. And that's
I think I set forth how it does it. The question is a defendant required to go through that process?
So if I could answer your question, and I see my time's expired, the process that the defendant has to go through is the same process for every other crime that's charged, which is looking at the statutory definition. And I just want to be clear that the statutory definition is...
That's correct. Where the indictment states what the elements of the crime. I mean, yeah, it's bare bones, but it states the elements of the crime charged.
More clearly than that, it states the statutory definition, which is singularly unique to that specific penal law provision. The section title, the section number, the statutory definition, they're all cross-references to each other, which is why you look at the history of the indictment law in this case. It says if you say one of those three things in an indictment for a traditional crime, right, where you just have whatever is being charged is the same as a statutory definition, that's sufficient. So when you have, you know, an indictment, I know that this isn't normally a crime that's indicted, but, you know, third-degree robbery, if you state third-degree robbery in the title, that incorporates the statutory definition in those elements because they're all cross-references to each other.
So in this indictment, had you added to the indictment in this case and taking the language of 130.52, by degrading or abusing such person, if you had added that as a factor, the indictment would be clearly jurisdictionally defective, because then it could have been 130.52 and it could have been 130.55.
I think that's exactly right. And I don't think the people need to do any more than, it's never been the case that the people have had to say, we're alleging the statutory definition, and by the way, only this, no other crime, because that's implied.
But the first count of the indictment talks about for the purpose of gratifying defendants, for the purpose of degrading and abusing such person, and for the purpose of gratifying the defendant's sexual desire.
Right, and so in Sanger...
That's the first count of the indictment.
Right, and so in Sanger, you know, Sanger, one of the arguments that the people made was, well, we also indicted the underlying offense, and so the defendant should, like, assume that that is actually what we're charging in the count of aggravated family offense in that case, which the Court of Appeals did not buy, and I think reasonably so. But in here, I think just the way that the indictment sets out, it's even clearer to a defendant that obviously count 2 does not charge forcible touching because the first count tracks a statutory definition of forcible touching. And I don't think that that is what should make this indictment sufficient, but I think it certainly highlights why everybody at the trial level in these cases understands what's happening. That's what happened in Lacey.
You would argue in this case that the first count is not jurisdictionally defective because that was setting forth 130.52.
Exactly, and that's what the trial court said in this case. The trial court said on the record before this case, obviously a defendant didn't object because he agreed. It was obvious that the first count was prosecuting a theory of forcible touching. The second count was prosecuting a theory of third-degree sexual abuse. It's the same thing that happened in Lacey, by the way, where the defendant's omnibus motion said, I acknowledge that I'm being prosecuted for persistent sexual abuse with third-degree sexual abuse as the underlying offense. The people at the trial level understand what's going on, and I think that the clear rule in Sanger is what should control in this case.
Well, maybe the people at the trial level don't understand what's going on because they haven't read Lacey. But thank you. So we do have a difference here because in Lacey, it was a one-count indictment, which simply stated subjecting another person known to the grand jury to sexual contact without the latter's consent, one count. And then in this matter, we have 2 counts. the first count, which talks about the degrading and abusing such person for the purpose of gratifying the defendant's sexual desire. And then we have count 2, which is the count that we are concerned with, which talks about sexual contact to placing his hand on said person's buttocks without her consent. So is that not a significant difference from Lacey?
I don't think so, Your Honor, because Sanger does make pretty clear, I think, that sufficiency is assessed count by count, and you can't look to a different count to bolster what's lacking from the language of the count itself. I would just like to note very briefly, respondents said this is the first panel to address Lacey post-Sanger. That's not quite accurate because, as you know, the Lacey panel itself addressed a motion for re-argument based on Sanger and denied it.
But does not the second count take away some of the guesswork that you were making reference to?
I don't think so. It's certainly different than Lacey. It's not exactly the same. I don't think it's different in a way that matters for the outcome, because ultimately the problem here is that the elements that are alleged are common to all 3 offenses, and there's nothing else that specifically says which offense it is. And what I think is crucial, this is a perfectly common
Which element that's alleged is common to all 3 offenses?
I'm sorry?
Which element that's alleged is common to all 3 offenses?
Sexual contact and without consent. Those are the 2 elements, and they are both common to all 3 offenses. And what I think is important here is also that is a perfectly ordinary, common sense way of speaking to describe the offense of forcible touching, subjecting another person to sexual contact without their consent. It's not the statutory definition, I'll grant you, but the criminal procedure law requires a short and plain statement that makes out the offense. And even in this case, the people characterize the offenses as, basically the same with some minor differences in mens rea.
Thank you. I'm sorry.
I'm sorry, Your Honor, just very briefly. I think the issue that this court identified in Hardware and Lacey is really probably unique to this statute. Sanger addressed a different statute, and it did not establish anything like the rule respondent is now urging. There's just no reason to retreat from the holdings of Lacey and Hardware. Thank you.
Thank you. Thank you both. Markel Finance versus Sutton. Yeah, I did. I skipped one. Okay. Thank you. Go ahead, whenever you're ready.
Good afternoon. My name is Parmenion. May it please the court. My name is Parmenion Patias of Stortsburn, 437 Madison Avenue, New York, 10022, here for appellants. The question of material fact is whether Middlegate cloaked Mayor Sutton with apparent authority. They gave him an office back in 1996, which he maintained until he passed away. They gave him the respect of giving charities, meeting with the rabbis, and all charitable institutions on behalf of Middlegate. So we need to look at plaintiffs and defendants. Plaintiffs and defendants here are all members of the insular and deeply, deeply religious.
So we addressed this once before, right? We had another case involving this back in 2022?
Yes. So the question before us is whether Middlegate cloaked Mayor Sutton with apparent authority. And to decide that, first of all, this is a question of fact that should go to the jury, and then we have enough facts already alleged to create an inference of apparent authority. The parties all belong to the deeply religious Syrian Jewish Brooklyn community. The appellants here are 4 or 5 ladies, actually. One of them is in her mid-90s. The other 4 ladies are approximately 70 years old or older, which were not in that community expected to participate in the investment of family monies. Once their father died, they looked towards the next patriarch, practically, which was their cousin Mo Malek, and they say themselves, we looked at Mo to take care of us. And then we look at defendants, we look at Mayor Sutton, and we look at
counsel, I have to say that the facts that are alleged are troubling. They're really troubling. We're talking about $11 million, and we're talking about no written agreements here. And then we're looking at a fax, right? We're looking at a fax, and trying to discern what relationship that has to the complaint. How do we get around the fact that the facts doesn't say very much?
Well, this is indicative again of the community. It's a lot of dealings that don't go on paper or didn't go on paper in this case, where Mo, the cousin of the ladies, advised the ladies to go and talk to Mayor Sutton. Mayor Sutton, who for over 2 decades had been cloaked with apparent authority to act for Middlegate security.
So what evidence do we have? What is there in the record? I recognize you're saying it's the community, so therefore you're not going to, it's a close-knit community, so therefore you may not have any written documentation or anything. But what evidence do we have at all that would bind Mayor with, or suggest that Mayor had any authority to bind Middlegate?
They gave him an office back in 1996 in Middlegate Securities, and then they gave him the respect of giving charities, meeting with the rabbis and all charitable institutions on behalf of Middlegate.
But
The
what
rabbis-
evidence is there regarding this transaction that there was apparent authority? So, for example, during the course of the meetings, was Middlegate ever even mentioned?
There is nothing on the record about Middlegate being mentioned.
Did plaintiffs ever go to Mayor's office, which was at Middlegate?
No, they went to his home. They only met with him, if I'm not mistaken, once at his home. But then, when their testimony, they testified that it was a very pleasant meeting, it was a very nice meeting, and they make no mention of any of the actual financial discussions because there was no financial discussion.
So where's the meeting of the minds?
The meeting of the minds is between Mo Malek, the cousin of the ladies, and Morris, and Mayor Sutton.
How is that borne out in the record?
Well, that is the material question of fact to be decided by the jury. Thank you.
Good afternoon, Your Honors. Evan Weintraub, Wachtell Misri LLP. May it please the court. From Your Honors' questions to counsel, it's clear that Your Honors are hitting the nail on the head here. There was
It's not to say that we're happy.
Your Honor,
Don't get this wrong. We're talking about $11 million that
absolutely, Your Honor.
were invested without a written agreement, and these ladies say that they lost all their money.
Your Honor, to be clear, and as we put forth in the papers, these monies were a family that were generational tax cheats that had
Generational what?
tax cheats, Your Honor.
Tax cheats?
That's correct.
That's what you said?
Yes.
Oh.
And it's in the record that all of these monies had been hidden in Swiss bank accounts, in Luxembourg bank accounts under Panamanian Corporation's name since the early 1980s.
So if the money belongs to IRS, then shouldn't the money be returned to them so that they can pay their taxes?
One would think, Your Honor, but that was not part of this case.
Right.
But what was established in this case, Your
I think the point was that your comment that they were historical tax cheats or whatever is totally irrelevant to the issues before this court.
Well, then let me address the issue that
Please do so.
of apparent authority. Appellant's case and their papers rest on the entire premise that there was some apparent authority that cloaked Mayor Sutton with the authority to enter into these transactions with the appellants on behalf of Middlegate. But as the long line of cases in this state establish, in order for there to be apparent authority, there has to be some manifestation of words or conduct from the principal, here that would be Middlegate, to a third party, here would be the appellants, that would give reason for the appellants to believe that the agent was cloaked with that authority. Their entire case, as counsel stated, was that they relied on their cousin, Mo Mala, who introduced them to Mayor Sutton. The problem here is Mo Mala has been deceased for a long time. He never gave any testimony in this case. He never gave a statement in this case. So this is all speculation as to Mo Mala's subjective belief as to what he thought Mayor Sutton's representation was if any, on behalf of Middlegate. This is a new theory that has no support, no case support, and it was not even argued below on the summary judgment. It wasn't preserved for appeal. They're making it for the first time here because they're showing this is a desperate attempt to try to keep a case alive when, again, there is no connection between the plaintiffs and respondent Middlegate Securities. If there's any other questions, I'll rest on our papers, Your Honors.
Thank you.
Thank you.
Two things I would like to say. First of all, the manifestation of the principle may be made either directly to a third person or may be made to the community by continuously employing the agent. This is restatement second of agency.
But that's what I was asking. I was asking, is there someone or an affidavit? This is a motion for summary judgment. So was there an affidavit from someone in the community or with knowledge who could attest to the relationships?
Well, the relationships come from Joe Towell, who is the cousin of the ladies, and we also have the testimony of Mr. Bluestein, who acted at some point as the lawyer for Middlegate Securities, and he himself said that he thought at some point that Mayor Sutton was an owner of Middlegate.
He thought at some point.
He thought, at least that's what he testified, that he thought that Mayor Sutton was the owner of Middlegate Securities.
He thought. So do we have, is there anything, any registration or anything of that nature concerning the business which shows that relationship?
No, but that would be actual authority. We're talking about apparent authority here. So the fact that the way they acted created the appearance of authority is all we need.
Well, we need something to show some type of authority.
Exactly. And then we have the office, which he had since 1996. And then we have the fact that he is allowed to represent the company to the rabbis, the highest echelon of this tightly knit community. And he does that for decades on, and he he gives out the charity monies. So it was reasonable in that community, in that locality, to assume that he had the right to bind the company.
Does the record show that charges were brought, criminal charges were brought in with respect to any of this?
No, Your Honor. Thank you.
Thank you. And my apologies, I did, skip two cases, so I am sorry. Handover Company versus Home Depot.
May it please the court, Kevin Brown from Minson Gold for appellant plaintiff, Handover Company Store. What's at issue here was a simple transaction by which Handover sold its brand and its inventory to Home Depot. In the lead up to that deal, Home Depot had ample time to conduct due diligence, to look at testing records, to look at Handover's inventory. It chose not to do so. Then in the wake of closing the deal, months after the deal closed, Home Depot began extensive testing of Handover Company Store's products and discovered that some of the products had issues with the packaging that needed to be repacked.
So money is left in escrow to cover any eventualities, and there's a year period at which that escrow fund is subject, right?
That's correct.
And don't these issues at least initially start before that year period expires?
Right on the very cusp of the year.
But before the end?
But before the end, yes. They served a claims notice.
And then there are these allegations that there are products that do not comply with legal requirements. And I guess there's an issue as to how much the liability is for those products, right?
That's correct, yeah. And there are two categories of products. There were certain children's bathrobes that were recalled by the CSPC, and we concede, for purposes of today, that we would have to pay for those. They couldn't be sold, at least for the refunds that were actually sought from robes that were purchased as a result of the recall, and for the price.
For the whole inventory, right? Because the inventory couldn't be sold.
The inventory couldn't be sold, but the overwhelming majority of it that was sold in the past, nobody came in and asked for a refund. So most of the robes had been sold prior.
But anyhow, as to the damage finding by Supreme Court, where is the reversible error?
Well, the reversible error is in the fact that the asset purchase agreement assigned to Home Depot the risk that certain of the products couldn't be sold profitably. So there's a distinction between the robes, which couldn't be sold at all, and we concede that, and the other products that may have had some issues with the repackaging that could have been sold, maybe at less of a profit, maybe not at a profit, if they were repackaged. Home Depot concedes that about 30,000 SKUs it did repackage and sell. Apparently, toxic chemicals in packaging is not an uncommon thing in this business where, as a retailer, company store was buying from wholesalers and then turning around and selling it. The issue for the damages at trial are the $600,000 of things that Home Depot, for whatever reason, decided that it didn't want to repackage. And the question is whether the asset purchase agreement gave them the right to just decide on their own not to try to resell those things. And our position is, though there were things about legal to sell in the asset purchase agreement, there was also a representation that there was no, we disclaimed merchantability, we disclaimed profitability in sales of the future products that were being purchased. And to balance that, those representations in section 5.25 and 6.8 of the APA against the other provisions is to say, well, it's one thing for the robes that couldn't be sold, but for the things with formaldehyde in the packaging, too high a level of formaldehyde that could simply have been put in a new bag, Home Depot should have borne that risk, the risk that those things couldn't be sold. The other issue in the case on our appeal is the question of the prejudgment interest. It is our position that the parties here decided, as the Court of Appeals has said, to chart their own course and to opt out of CPLR 5001 prejudgment interest. And they did so by putting a sum certain in the escrow account, and within the escrow agreement, section 3B of the escrow agreement, saying who gets the time value of that money. And the escrow agreement said that money would, the interest or income generated by the escrowed funds would in your...
So, counsel, I know that the flammability standards, that the robes failed flammability standards in October 2018, more or less, and now we're in 2024. Ostensibly, even though the people who bought those robes didn't come forward because they didn't know what the deal was, right? Presumably. You're saying that the money should be returned, the money held in escrow, because enough time has passed. But what happens if all of a sudden little children get burned because there's a fire and there's all these lawsuits? I mean, is there a proper amount of time?
I don't know what the exact proper amount of time is, but these were children's robes that were purchased prior to the 2017 closing. The children for whom they were purchased have long since outgrown them. The recall has been in place and has been advertised going all the way back to 2018, and no one has come forward.
You have to counter that with the representation that even though the assets were sold as is from the company store, the plaintiff represented that its operations were in compliance with all environmental laws. So there's a juxtaposition, there's a balance. How does it fall?
Well, when it comes to the specific representation with environmental rules, if you look at that representation, they are all about environmental rules that are enforced by the EPA, such as pollution and things of that sort. We would say that that doesn't apply to the robes.
That's not robes?
That's not the robes here, no. Those were about pollution and things like that, something that the EPA would come in, and we complied with that representation.
Thank you.
Thank you.
May it please the court, Ronan Doherty on behalf of respondent and cross-appellant Home Depot. There were two parts to this dispute. The first is about whether or not the products, the inventory at issue here, 356 different product items complied with all applicable law. That's the representations made and whether they're breached. And despite what's in Handover's briefs and what you've heard today, all of that was admitted at the summary judgment stage of this case. No evidence was presented that any of these products complied with applicable law or any of the representations. The failure to comply with applicable law, and it's all the laws, Section 1.1 of the APA defines the applicable law, and it's everyone you can think of, all the states, not
I
little.
referenced the environmental laws that are on A85, but on A84, you have compliance with all applicable laws.
Right, and so it violated 3 different provisions of the APA for which Home Depot could seek indemnification. And so that's why by the time of trial, the issue of whether or not there was a representation that had been breached or had maybe been preserved and accepted in that first part of the trial wasn't an issue. The trial court held a damages trial after concluding that all of the arguments that Handover made about excluded types of losses, that those didn't work under the law and under the APA. And so this trial was just about the amount of damages. And so what Handover's tried to do on appeal is try and resuscitate or resurrect an argument about the types of representations to try and confine what losses Home Depot can recover. But that doesn't work here because the parties in this very heavily lawyered transaction wrote down in black and white what losses would be recoverable. And all of the losses that the court awarded are in black and white available under the agreement. And then as to the amount, the trial court heard evidence, had a bench trial, listened to the witnesses, endured their cross-examinations, made his credibility findings, and came up with the judgment that found that Home Depot...
You were given prejudgment interest, right?
Right, we were given prejudgment interest.
What's the support for awarding prejudgment interest here?
It's just straight mandatory statutory interest under CPLR 5001. And Handover concedes that we're entitled to that unless the parties contracted out of it. The argument here is that the escrow agreement somehow manifested that intent to opt out of interest. But Handover is, again, comparing apples and oranges. The apples of the interest and income at issue in the escrow account is just the interest on the funds as they sit there. Handover's entitled, absent a claim, Handover's entitled to get the interest on its money as it sits in that account. But CPLR 5001 interest, which the trial court has a duty to award, is an entirely different category of interest, and that is allowed and required by the statute. And if there were any doubt here, the definition of losses here in APA 10.2a includes interest.
If I understand your adversary correctly, the argument is give us back the money that you haven't returned to people, that you haven't reimbursed to people so far because there have been problems with the products.
So this is a different category of damage.
That is a different category.
Specific to the robes.
Yes,
Right?
please.
And here the issue is, again, the contract very specifically says that this is a loss Home Depot shall recover. The definition of loss in 10.2a includes capital L liability, which is separately defined under 1.1 of the agreement, and that says all liabilities, debts, contingent or already accrued, due or not yet due. And sitting on Home Depot's books is a liability for $450,000 and change, right down to the penny of the money that customers would get if they came in and asked for their money back for those robes.
That falls into the not yet due category?
The liability is contingent in the sense that it's real, and we know what it is. It's not a speculative amount. What Handover and the company store sold these robes for is a specific number we have. And if the folks come back and turn their robes in, Home Depot absolutely have to give them their money. And so it's a contingent liability, and it might not be due yet, but under 1.1 of the agreement, in black and white, it is due to Home Depot. With the court's permission, I'd like to move to our request for attorney's fees. And once again here, the issue is whether the contract provides for it. Handover agrees, number one, that the trial court got this issue wrong. Home Depot did not ask for attorney's fees under Section 4.4c of the agreement. That provision was never triggered because this transaction closed. Home Depot asked for attorney's fees under the 10.2a standard definition of losses, which includes damages, costs, and expenses right next to the word actions and suits. When read in context, that is broad enough and general enough to cover the request for attorney's fees. Now, the New York law requires that the fee shifting be clear in the contract, but there's nothing in the case law that requires any magic words. And so the parties here, again, well represented by counsel, were clear, but they were not redundant here. And that is all of the case law. We've cited numerous cases, both before and after the case on the Hooper case, on which Handover relies, where that language is sufficient to award fees.
So costs and expenses equals attorney's fees?
In this context, yes, when that language appears right next to actions and suits. And if we needed any further confirmation, that language is sufficient by itself under New York law, and our briefs cite those cases. But if you needed any help there, Section 4.4C, which the trial court referenced, again, we're not petitioning for fees under this, but there it says the word damages includes attorney's fees. And so to hold for Handover here, the court would have to say that damages includes attorney's fees in 4.4, but not in 10.2, and that makes no sense.
Thank you.
As Mr. Doherty noted several times, this was a very heavily lawyered transaction. Home Depot was represented by Weil Gottschill. It's a world-renowned law firm. Weil knows, the lawyers know, how to write a first-party attorney's fee provision that allows for the prevailing party to recover attorney's fees. We know that they know how to do that. We know the parties here knew how to do it because they wrote it in 4.4C. If a party terminated early prior to the closing and there was a willful termination, the other party, the non-terminating party, could seek its attorney's fees. We also know it because it's in the escrow agreement. If one of the parties sued the escrow agent under Section 6 of the escrow agreement and the escrow agent prevailed, there was a first-party attorney's fees provision. They could seek their attorney's fees.
So you do not read costs and expenses to equal attorney's fees?
No, in fact, I read it exactly the opposite for Mr. Doherty, which is I read it as a conscious choice not to list attorney's fees in the definition of capital L losses in Section 10.2A of the Asset Purchase Agreement. We know the parties knew how to say when you get to recover attorney's fees. They didn't say it. And so no matter how broad that definition of losses is, it doesn't encompass attorney's fees. Turning to the $400,000 of robe costs that have never been sought, we would say there would have to be some reduction. 20 years from now, if nobody ever comes in.
I was actually going to ask that question. At what point in time would the monies be released? I recognize it's contingent, but at what point in time would it be released?
I don't know the answer to that. I'm not an accountant myself, but I'm absolutely certain that at some point in the not too distant future, the people who advise Home Depot are going to tell them to start writing that liability down, because as time progresses, the chances that anybody is going to come in and ask for a refund on those robes substantially decreases. In fact, it's probably close to nil or nil now. If the court has no other questions, I see my time is up.
Thank you. Thank you both. Did I give you two? You did. Yes.
I won't take them, I promise.
So could you answer that question? At what point in time do those monies have to be dispersed?
The honest answer is there's not one in the record, and I believe that it would be an issue of accounting rather than law. But the issue here, again, to pick up my friend's point, these folks knew how to write a contract, and they put contingent liability, due or not due, right there in black and white as a recoverable loss. And so therefore, we think that the trial court was right to award those, if that's what the judgment says, and we'd ask the court to affirm. And put reverse on fees.
Thank you. People v. Tavon Johnson. And I know you were not supposed to be last, but you are last, so again, I am sorry.
Good afternoon. May it please the court, Alexandra Forbes of Cleary, Gottlieb, Steen, and Hamilton, in conjunction with the Office of the Appellate Defender, representing Tavon Johnson. This court should adjudicate Tavon, who was a 16-year-old kid at the time of his crimes, a youthful offender, or in the alternative, reduce his 9-year sentence in the interest of justice. Tavon had a very difficult childhood, growing up financially insecure with a father who was incarcerated. And the pre-sentencing report in this case specifically acknowledges—
I'm sorry, you want reduction and YO, or do you just want reduction?
we're arguing for a youthful offender determination, or in the alternative, a sentence reduction of his 9-year sentence.
And that 9-year sentence, the original sentence was 11, then it went down to 10, and now it's at 9.
It was originally at 11. It was remanded to the court for
Right.
resentencing, and that in 9 years. So it was a 2-year reduction.
Right, okay.
And the exposure was what?
Well, technically, a much longer sentence was possible. However, nobody in this case has indicated that the maximum was remotely possible. Indeed,
But what was the number?
the number cited in the maximum, I believe, is 50 years. The
And
other
no one-
16-year-old co-defendant in this case was adjudicated a youthful offender, and was given 4 years of probation.
So if I'm not reading the record incorrectly, this defendant was the shooter, was he not?
That's correct, and he has expressed sincere remorse.
No, but my point was, you were stating that a co-defendant received probation. That co-defendant was not the shooter. That was my only point.
The co-defendant was involved in another shooting several days before, and he was also involved in the shooting at issue here.
He didn't have the actual gun and fired the weapon.
The co-defendant, no.
Yeah.
Not in
That's
not
what
in
I
the
meant by
November-
shooter.
Not in the
Not
November 27, 2016 shooting.
Yeah.
But it's important to consider that the pre-sentencing investigation report in this case specifically acknowledges that it was the tactic of the gang that he became involved with to involve young recruits between the ages of 14 and 16, young boys like Tavon, who were vulnerable, to commit acts of gun violence. And that is precisely what happened here. Tavon was an easy target. He was only 13 years
And counsel, when I inquired about what the exposure was, I inquired because much of what you're bringing forward as mitigation was contemplated in the sentencing. Is that not correct?
The same evidence was at the sentencing. However, this court serves an important role as a check on the discretion of the sentencing court. And here, the 9-year sentence on resentencing is still excessive in light of the fact that he was a 16-year-old kid at the time and the various mitigating circumstances at play in this case. Tavon has accepted responsibility for his crimes. He has been in prison for more than 7 years. He has been working diligently to turn his life around. He has expressed a desire to return to the community that he came from and act as a mentor.
So he's out next year, if not sooner, right?
He has
9
been-
years? He got a flat 9?
9 years, and he's been in prison, I believe, a bit over 7 years.
So he should be out like next month. I mean, I don't know what month, but he's out soon. On the 9, he should be out now.
I believe he still has almost 2 years.
No. Well, I mean, I don't know. On 9, you're not going to do 9 unless he is a disciplinary problem. I don't know. But on 9, he should be out now.
So his earliest release date would be soon.
Yeah.
We would request a sentence reduction of no more than 7 years in this case, just to make sure that he is released as soon as possible. Thank you.
Good afternoon. May it please the court. Max Bernstein for the people. Just to begin with the question of the earliest possible release date. According to the Department of Probation and Parole's website, the earliest release date is this August on the 9-year sentence.
August of this year?
August of this year, yes. Justice Bivens squarely found that the defendant was not eligible for a youthful offender determination because he did not satisfy the statutory requirement under procedural law section.
Armed felony?
On the felony, yes.
Armed felony.
Armed felony requirement.
So it's 2 counts of attempt murder, 2 and 2 counts of assault in the first, right?
Sorry, those are the indictment counts. The actual counts that he pled to there were 2 assault counts and a conspiracy count. The
2
target,
counts of assault in the first degree.
yes, and this is specifically
Co-defendant Gaston was convicted of murder, right?
yes.
What was the defendant's connection to that, if any?
Vic,
Is he just a co-conspirator?
I believe he was just a co-conspirator on that murder. Clearly, defendant committed an armed felony here. He fired into a crowd of people, and then after the crowd dispersed, he specifically targeted an individual who was standing in front of a deli, shot at that person multiple times, hit them in the chest, perforated their lung. He also participated in quite an extended period of serious violent conduct. He was charged with participating in an assault where a person was slashed in the face, where he was accused of the slashing. He participated in an armed robbery where he held the gun. This was not thoughtless or
How old was he?
It was over the course of 2 years. So I believe the earliest offense was close to being 15. By the end, he was just after 16. The requirement of 7/2010 is that there has to be mitigating circumstances that bear on the conduct. There is no evidence at all in the record that there were any mitigating circumstances that bore on the conduct that took place here. And that was precisely what Justice Bybin correctly found. The only allegation that's raised here at all, that there were any mitigating circumstances that bore on the conduct, were raised only in defendant's own resentencing submission. It was the self-serving claim, which there's no record evidence for at all, that someone put the gun in his hand and told him to fire. And again, there's no support for that claim anywhere in the record. Justice Bybin, who took this plea, noted that she watched the video of the shooting multiple times. She never saw any evidence of that. So there is no basis to find that that would be sufficient to overrule.
But she reduced the sentence, didn't she?
She did reduce the sentence, but not because she found there was any mitigation with respect to the actual conduct of the crime, but simply in consideration for the good work that he had done afterwards, which came up only in the resentencing, and obviously which she couldn't have been aware of at the time of the initial sentence. Thank you all very much.
Your Honors, I'd like to address the eligibility point. This court remanded the case to Justice Bybin to make an express youthful offender determination, including a finding of eligibility. That is what is required under the law under Middlebrooks. Justice Bybin said on the record that Tavon was technically eligible for YO, but declined to adjudicate him a youthful offender on the merits. And there were mitigating circumstances bearing on the nature of the offense here. This was, as I mentioned, he was under an immense amount of pressure from the influence of older men who recruited him as a 13-year-old kid. This was the nature of the gang. This was the recruitment
And all
tactics.
of these things were mentioned to the Judge Bybin at the time of resentencing. Were they not, the mitigating factors you just mentioned?
That's correct, but as I mentioned, this court plays an important role as a check on the discretion of the sentencing court. And the various mitigation here shows that a 9-year sentence is excessive based on his age, based on the amount of pressure that he was under, his acceptance of responsibility, his sincere expressions of remorse, and the positive strides he has made in prison. Respondent has even acknowledged Tavon's, quote, positive behavior while incarcerated in its brief. And this factor, as well as the strong support network that he is returning home to, you have seen in the record the letters of support from his family, his community members. His father has been released from prison. He has a strong network, as well as the resources of the Office of the Appellate Defender, who are going to make sure that he has a chance. He is now nearly 24 years old. He has served more than 7 years in prison for a crime that he committed as a child, that if he had committed it just a few months earlier, he would have been a juvenile offender facing an entirely different sentencing scheme. And as I mentioned, the maximum exposure here was not even remotely contemplated by anyone in this case. I would submit that 9 years is excessive, and we would ask this court to please adjudicate him a youthful offender or reduce his sentence in the interest of justice.
Thank you, and also please thank Clary Gottlieb.
Clary Gottlieb.
For allowing you to defend this case.
Thank you very much.
Thank you very much.
Still at it.